Hmm.
First, if I beg to mention item number 33 of this, I have taken the consent of the other side. In this case, I have been led by the change of the case being tied up in other matters. Can it be taken up next week?
PRPIO.
IO. There was a stay order operating. We have filed our objection. It needs to be heard, but next week.
Why? Why an adjournment in a CRPIO?
I have been listed for.
Okay, well, with the close of the CRPIO, IO become infectious then. No adjournment. CRPIO don't mention it. Hmm.
Yes, please, Your Lordship. Your Lordship, I beg to mention for listing of second appeal, Your Lordship. 2013 matter, Your Lordship.
Hearing,
Yes, Your Lordship.
go to the registry.
I beg to mention item number 36. Kept know that the visa expired 2023.
Who? Item number
36.
who expired?
It is
When?
the year 2023. First part of it.
Okay, we'll abate it. Don't worry. Huh?
Substitution.
Substitution doesn't arise. You have not done it by operation of law.
2-3 days back, we came to know.
It is not material. The law will take its course. It is not required for this court to pass an order. Automatically it abates. I'll help you when the matter reaches. This is 2013-15 matter. Nothing to next.
RSM matter 131 of 2012 matter has already been listed twice.
What matter?
Regular second appeal matter, but that has not been tasked by the before the Federal Court, but due to paucity of the time.
Tell the registry to again list it.
Well,
You list it. I'm not going to mentioning not so.
Apply to mention item 28 of today's date.
Hmm.
See, Lordship, 2 weeks time to file the written objections.
Written objection to what?
To the restoration application filed by the petition court.
How many days?
Lordship, more than 1 year they have filed the restoration.
Mr.
A. Kakoti.
Ikakoti, the learned counsel appearing on behalf of the respondent submits that 2 weeks time is required for filing the reply to the restoration application. List the matter again on 3rd of June 2024. In the meantime, the reply prepared.
May I please, Your Lordship? Your Lordship, I beg to mention item number 7 of today's date. Lordship, Senior Mr. Bisida sir was about to appear, Your Lordship, but he is not well today.
Who is not well?
Bisida sir.
Bishidas is where?
Item number 7, Your Lordship.
For whom?
For the appellant, Your Lordship.
2023 RSA is coming for order 41 rule 30.
He was about to appear, Your Lordship, but he is not well.
Don't worry. We dismiss it. Then your problem is not there.
That is for the day, Lordship. He is not well.
The request to the learned counsel for the appellate matters can be shown to be listed after 4 weeks.
Please, Your Lordship.
Item number 22.
Hmm.
We have to file an application for striking of the name of the performer defendant number 2.
Who died?
Performer defendant number 2. Performer defendant number 2.
Why do you need it? To strike off the name.
Absolutely. Earlier occasion it came that we had to file an application these days because for that. So that is it.
Mr. Boning, unnecessary, these performer respondents whom
Correct.
you have nothing
Correct.
to do, they are being substituted and the matters are getting delayed. You know,
Let the matter be called. May I please, Your Lordship?
Hmm.
Your Lordship, in respect of item number 48, Your Lordship, yes, Your Lordship, for the last order, we have to file an additional affidavit. We have filed it yesterday, Your Lordship. Perhaps it's not on record.
bring it. Bring it on record.
Yes, Your Lordship.
May I please, Your Lordship? Lordship, I beg to mention for listing an RSA matter.
You mentioned it yesterday.
Yes, Lordship. Your Lordship asked me to mention it too, but then the division bench.
Then
That's
you
why
got
I
it
put
from your senior. Why is it required?
yes, my Lordship. The matter has been pending since 2019 without being admitted.
We'll have it on when?
My lordship on
You are for the
Monday.
respondent?
Yes, my lord.
Oh, that is the reason why. Okay.
On
We'll
Monday.
have it on 27? 27.
Oblige.
In respect of atmosphere safety, they have thought that here from hypothetical purpose.
Huh? Oh, yes.
But they have not taken any.
Worship, I have called the filing advocate. He has not picked up the phone. Again, after
But they
mentioning, I have to
repeatedly
call.
thought that
Because written
They have-
objection.
They have repeatedly.
Okay. Adjournment which was granted is cancelled. We'll take it up when the matter reaches you.
Yes, ma'am. Yes, ma'am.
28 to adjournment.
The petitioner immediately settled the matter. And
What's your name?
Eke Hatha.
Hmm?
Eke Hatha.
AK?
Annan.
You are there? In this
No.
appeal?
No.
Who is there?
MJ Kadir.
Huh?
MJ Kadir appeared.
Where is he?
MJ Kadir, I am appearing.
You Dean J. Kadir, SP Law School, SYM. And who is there?
MJ Kadir. Fine.
MJ Ali is not here. See, you can't make a mention of these type of matters in this manner.
Lord,
Ask your whoever it is, ask him to come. Because you see, you will be in difficulties. Tomorrow I'll record your name and you will be trouble. Unless you file an affidavit.
yes, my lord, in the post with
Where is MJ Kadir?
yes.
Bring him. Ask him to come. Okay.
Pilot. We want to introduce petition to file a petition under section 258 of Indian Succession.
Hmm?
So we file for substitution of the legal heirs of the deceased appellant, but that was objected by the other party on the ground that it's on and as per the provisions of letter of administration. In that we will file a fresh petition. We may be allowed to introduce this.
Mr. M.U. Mahmood, the learned counsel, heard Mr. M.U. Mahmood, the learned
Aye.
counsel, hearing on behalf of the appellant. Appellant.
Yeah.
Mr. C. Sharma appears on behalf of
Respondent 5, 7, 8, and 9.
respondent numbers
5, 7, 8, and 9.
5, 7, 8, and 9. The learned counsel appearing on behalf of the appellant submits that he may be allowed to withdraw the instant application, instant appeal. So, taking into account the above, the instant appeal stands closed on withdrawal. So, I stands closed on.
All right.
I'm appearing for respondent number 6. Respondent
Yes, put your name, give your name. Mr. 8 or hi, Pura
Pura.
appears on behalf.
Appellate.
Yes,
This application seeking for transfer from the court of additional district of Karimganj to North Section.
why?
On the ground of my inconvenience.
Huh?
On the ground of my inconvenience.
What is your inconvenience?
I'm a lone mother and I'm maintaining two
You are?
lone mother. Mother.
You have a mother.
No. I am a mother maintaining 2 children. I have no stable source of income, and it becomes difficult to cover a distance of 1820 kilometers
1820?
from Karimganj, from North Lakhimpur to Karimganj. Right now, I'm deciding in North Lakhimpur. And earlier I also filed a maintenance case before the JMFC North Lakhimpur.
Notice making it returnable by 24th of June 2024. Steps be taken upon the respondent by way of registered as well as usual within 3 days. In addition to that, steps is directed to be taken by way of trustee routed to the registry of this court and file an affidavit of service on a trustee. It is made clear that the the petitioner need not personally need not affect personally the service by way of dusty. It can be done to some other person known to the petitioner. And however, that person who affects the service by way of dusty has to file an affidavit. This is an application filed under Section 24 of the Code of Civil Procedure 1908 seeking transfer of title suit divorce number 15 of the 2024 pending before the Court of the Additional District and Session Judge FTC to the Court of the Additional District and Session Judge FTC, Lakhimpur, not Lakhimpur. It is the case of the petitioner that the petitioner is living at her parental house,
At a rented house.
at a rented house, and is living at, is residing at North Lakhimpur, which is at a distance of around 1800 kilometers from the district court at Karimganj. The petitioner further has 2 children who the petitioner has to look after. It is under such circumstances, on account of the inconvenience faced by the petitioner, the instant application is filed. So taking into account the above, this court is of the opinion that this is a fit case. This court is of opinion as the question as to whether the proceedings is required to be transferred or not has to be decided by this court in the facts stated in the application. Accordingly, this court stays the further proceedings of title suit D 15 of 2024 pending before the Court of the Additional District and Session Judge FTC at Karimganj till the next.
Appellate.
Yes,
The matter may be passed over for the time.
why
Period.
are you asking for? Where is the order? Injunction. Means appeal dismissed. Till the, you are for the defendant. Okay. The learned counsel on behalf of the appellate petitioner being not aware of the case, matters can be adjourned to be listed again on 27th of May 2020.
5
The Lordship said
What is the order you are challenging? Yes, Mr. Dasu. What do you have to say in this order? What do you have to say about this order?
So far this order is concerned, Milord, learned court below was of the view, their case is that your name has been mutated in the Jamabandi, but you don't have any title. That is their case. Our case is that in the written statement is that yes, we have not purchased the salary, we have purchased the land without any register selling. That is an admitted position. Now they want to examine the revenue officials to establish this thing. But it is already been admitted. If your lordship goes through our written statement at paragraph 15 of our written statement, this is very much clear. The written statement is that, and for that reason, probably the learned court below was of the view that no witness is required to be examined because it is an admitted position. It is my understanding. Look. If you
They are
come to
the-
page
They are the
26,
plaintiff. They are the plaintiff.
they are the plaintiff.
They want to bring on record these documents.
No, they want to, they are the plaintiff. According to them, so far the defendant has no right, title, and interest, but her name has been mutated in the reporting record. Now they want to establish this thing that they have no right, title, and interest. For that purpose, they have amended the writ petition and filed an application under Order 16 Rule 1 to the effect that some revenue officials is required to be examined. But our condition is yes, what you have stated, that is correct. You don't have any enmity with your contention. That is, if your lordship come to page 26, paragraph 15. When if some revenue official comes, if your lordship allows that, we don't have any objection.
Yes.
Paragraph 26, page, paragraph 15, page 26. That regarding the statement made in paragraph, that the Khorgeshwar Rai, son of such and such, is the original owner of the scheduled land A. And after his death, the same had been developed upon his three sons, such and such, such and such, and such and such. And the answering defendant number 1 is the neighbor and as well as the auntie, both though not full-blooded, of the said predecessors of the plaintiff. After the death of the original Pattadar, that is the Khorgeshwar Rai, both the brothers approached to the defendant number 1. That is an admitted position. As well as her husband, both the brother approached the defendant number 1 as well as her husband, who was the railway employee, to dispose their share portion of land measuring it should be 2 biga, 2 biga to meet up the financial crisis. Accordingly, they sold their portion of land in favor of defendant number 1, and subsequently at the time of mutation, that is very much clear, though we have not stated specifically that it is unregistered deed, but it is by our mode of statement clarifies this thing. And subsequently at the time of field mutation, the said suit land was mutated in the name of the defendant number 1 by way of relinquishing as per the order dated 19/3/1997. 1997 of the Assistant Settlement Officer Bongaigaon, Revenue Circle Bongaigaon. And at that time, at the time of the field mutation, the suit land was mutated in the name of the answering defendant number 1. And upon taking the consent of the said brothers in presence of the nearby person. It is a case of field mutation. Since then, this suit land has been under the constant possession of the defendant number 1. And up till now, indeed, after the resettlement parties, Mr. Chaudhary is not here. Let her come. In
Well,
her absence, we will not.
Don't worry. I'll protect her right.
All.
You argue.
So it is their case. Now, if your lordship come to the impugn order itself,
You see, the thing is like this. What they were asking at page 34. The Jamabandi book containing the dark number 191,
page 34.
page 34. Corresponding to old dark number 263 as so and so. That is one thing. Chita book containing the dark number so and so corresponding to Iman, under Iman, records to be brought by the solicitor so and so of the year, that, and the old Chita book drafted the containing so and so in Iman. So they
So
want
they
to
want
produce.
some revenue record to be placed before the court.
These are the documents they want to place on record. They were actually calling these documents.
Yes, they are declaring it.
Now, if these documents, can certified copy of these documents not be given?
Yes,
Because you see, at the end of the day, if these documents, the court says that there is some admission here and there, and tomorrow you file an appeal later on, because these orders are not appealable. These orders are not appealable. So you may file an appeal under 104, 105, take this ground that this is not true. Where will they go? It is their case. Let them prove it. What is the problem?
no, I don't have any problem, Lord.
Then I think the court should have allowed it. Let them allow it.
No, no, so far the court view
You
is
didn't
concerned,
file
that-
an objection to that.
no, without recording these things, Lord, so far as concerned, Lord. If your lordship comes to page 37 of the impugned order,
Yes.
I have also heard the learned counsel appearing on behalf of the
I
opposite.
have read that, Mr. Dasgupta. The thing is like this. These orders are not appealable. Kindly take note of. These orders are not appealable. And as such, these orders are also not revisable. One can come under 227 against this order, it is okay. Now tomorrow, when you take up this right and challenge it, look here, it is the court who have taken, the court should not have taken it. And it becomes a ground of appeal. Then what happens? You can very well take these grounds. This or any orders passed in a suit proceedings, which are then not appealable or revisable, can very well be taken as a ground of appeal. And if you take that this court had, the trial court made that mistake at that point of time, and as such, on the basis of which this is being done is a case of perversity. How do you take care of that situation? So it is the plaintiff who has to prove. The plaintiff wants to bring those documents. Let him bring it.
The
Yes.
only thing is that
Now, madam, tell me. I didn't disturb your junior. Why you are not giving the certified copy of this document? Why do you need the originals of these at page 34?
Record to be brought by circular.
public.
You want what? The Jamabandi book. Why? You want only the extract of that particular portion.
Already amendment was allowed by the trial court.
Understood. But what do why you don't need the entire book. You need only that portion of that book.
That shows by relinquishment they have purchased.
Understood. So,
Prove that fact.
so therefore, the relinquishment is a question which needs to be produced on the basis of some document. It cannot be anything.
No, they
Unless
say-
you ask for production of the records of that case on which it has been done, which you are not asking.
But I am calling the circle officer and said that.
Understood. But you are not asking that record, which is the most pertinent record you should have asked. That under what basis the records of that case, that mutation case on which her name was inserted.
Fact, there was no mutation case. Their pleading is that their vendor put signature in the chitta by relinquishing his right title in favor of them. So they are the owner, and on the basis of that relinquishment, the revenue authority allowed mutation of the rest.
How? There has to be an order.
Lordship.
1997.
So they mention about the date of that order.
Yes, sir.
Lordship, 1997 is there.
Then why you are not asking for that document? That is the document which, or the records of that
Sure.
document
They
should
are
have
like-
included everything. These are certified copies which you can very well produce.
But to prove those facts, the official are required.
You bring official witness, there is no quarrel with that.
Sure.
But these are the documents, otherwise would that help you? Because your question is that how could the entry of a name be there? Or by any relinquishment, if there is a signature also to that affair,
Sure.
how can there be there? You cannot transfer by way of anything to that effect.
Yes.
And if there was no right of that particular person, the question of relinquishment does not arise.
Right there, but right is there. The
Uh,
person has right.
The defendant number one had right.
No, Lordship, the person who
Therefore, you see, how you cannot, by way of a relinquishment, you cannot confer a title.
Correct.
You may say, I give up my right. If you give up your right, the other person who have any right out there automatically gets the right. So it has to be therefore by way of a title document which has to be registered. These are all other cases. I'm not on that. But that defendant number one had to have the right to, for the effectiveness of a deed of relinquishment. You cannot convey by just signing out.
court and lordship by calling this person, they may not be prejudiced as because they will get chance to cross-examine them.
Therefore, this is an application under Article 227 of the Constitution challenging the order dated 6/6/2023, passed in Mise case number 43 of 2023, arising out of title suit number 98 of 2021 by the Court of the Munsif, Bongaigaon. The facts involved which led to the filing of the instant application is that the plaintiffs had filed a suit seeking declaration of their right, title, and interest in respect to the suit land, semicolon, for declaration that the defendants had no right, title, or interest over the suit land or suit land of the Schedule B or any part thereof, for recovery of khas possession in favor of the plaintiffs by evicting the defendants and their men from the suit land, for declaration that the inclusion of the name of the defendant number one in the periodic Hiraj Patta number 60, dark number 191 at Revenue Village, Dholaigaon, under Revenue Circle, Bongaigaon, is illegal, and the name of the defendant number one be struck off from the record of rights, etc. The defendants filed a written statement
Page
denying
24.
to the case of the plaintiff. However, it is relevant to take note of that at paragraph number 15 of the said written statement, it was mentioned that the Schedule A land was originally owned by one Khorgeshwar Ray. Upon his death, the said Schedule A land devolved upon his three sons, another Mohan Roy,
Another
ANANDA,
Right.
Mohan Ray, Dambudhar Ray, and Pankaj Ray. It was further mentioned that after the death of the original Pattada, that is Khorgeshwar Ray, both the brothers approached the defendant number one, as well as her husband, who was a railway employee, to dispose their share portion of the land, measuring
2 bigha.
2 bighas, to meet up their financial crisis. On the basis that it was also mentioned that these two brothers, who were the sons of Khorgeshwar Ray, sold their portion in favor of the defendant number one, and subsequently at the time of kill mutation, the said suit land was mutated in the name of the defendant number one by way of relinquishing, as per the order dated 19/3/1997 of the Assistant Settlement Officer, Bongaigaon Revenue Circle, Bongaigaon. In view of those statements being made, the plaintiff filed an application under Order 16 Rule 13 of the Code of Civil Procedure 1908 for the purpose of calling the defendant number, calling the circle officer, Bongaigaon, as well as the Serishtada RKG, Bongaigaon, as witnesses as well as also calling for certain documents. This application was registered and numbered as Ms. Case number 43/2023. This application was rejected by the learned trial court by an order dated 6/6/2023, primarily on the ground that as the facts disputed and raised by the petitioner, plaintiffs have not been denied and disputed by the defendant, there was no necessity for calling for the concerned documents along with the concerned officials to prove the said contentions raised by the plaintiffs. Being agreed, therefore, the instant application has been filed. I have heard Mr. R. Chaudhary, Ms. R. Chaudhary, the learned counsel, appearing on behalf of the petitioners, no? And Mr. A. Dasgupta, the learned senior counsel, assisted by so-and-so, appearing on behalf of the respondents. This court have perused the plaint, the plaint,
What meant to what?
wherein it has been categorically mentioned that the defendant did not have any right, title, and interest over the suit land. This court had also taken note of the written statement, and more particularly paragraph number 15, wherein it has been categorically mentioned as to how the right over the suit land accrued upon the defendant number 1. The plaintiffs have, in order to prove their case, wanted to call the circle officer, concerned circle officer, as well as the Saristadar, along with those documents which have been mentioned in the application. The learned trial court denied the said application on the ground that the opposite party have duly accepted those documents. But the fact remains that the plaintiff is entitled to produce the primary evidence of those documents. And for the purpose of proving the state primary evidence, the circle officer or any person duly authorized by the circle officer or the Saristadar or any person duly authorized by the Saristadar is also required to be examined. Else, this lacuna in the evidence may, at a later stage, affect the rights of the plaintiff. Under such circumstances, this court therefore interferes with the order dated 6/6/2023, passed by the learned trial court in the Ms. Case number 43/2023, and allows the said application filed under Order 16 Rule 1(3) of the Code of Civil Procedure in terms of the prayer contained therein at paragraph number 7. Mostly,
I guess
No stay.
That
Wednesday.
No, they were.
No stay.
Yes.
What is the stage of the suit now?
was at the stage of argument when we fight the petition.
It was at the stage of argument.
You said the stage of arguments, you.
At the stage of
Yes.
argument, amendment was adopted.
Amendment, what did you insert? Only the prayer.
Prayer for cancellation of the partner. So after that, we filed this application for
No, only prayer. You did not insert anything else.
no lordship.
In the plaint,
Plaint lordship that was amended, and amended plaint was already lordship submitted. Para 8.1, page 18.
you didn't file your written statement thereafter.
No, we didn't.
After amendment, they have
Then what has happened to the suit now?
this at the stage of argument or where the stage is ready.
But don't you think that you need to file now your reply? See, they have inserted a paragraph. Don't you have to file an amended plaint? Understood. If only the relief it is there, it is okay. But this particular paragraph 8A being brought, don't you have a right to file an amended written statement? Otherwise, it will have
That can be, yes, that can be given. Much of it.
it has been brought to the notice of this court that the learned trial court had permitted the amendment of the plaint at the stage of arguments of the suit. And thereafter, the suit was kept at the stage of arguments without giving an opportunity to the defendant to file their amended written statement. It is the opinion of this court that in view of the amendment made to the plaint, and more particularly wherein pleadings have been inserted by way of paragraph number 8, Roman 1, a right accrues upon the defendant to file their written to file an additional written statement. A right accrues upon the defendant either to file or not to file. A right accrues upon the defendant to file an additional written statement if they so desire.
That will be better.
However, there has been no opportunity being granted to the defendant to do so. Under such circumstances, this court, therefore, grants 30 days time from today to the defendants to file an additional written statement that is by 21st of June 2024. This court fixes the matter before the learned trial court on 21st of June 2024, on which date the defendants, till which date the defendants would be at liberty to file their additional written statement. Subsequent thereto, the learned trial court shall pass appropriate orders in view of the interference so made by this court to the order dated 6/6/2023, so that the relief which has been granted, relief sought for at paragraph number 7 of the miss case number 43/2023 is given due effect. With the above the instant plea.
If they file the written statement, if so desired, or if they want to file the.
What did I say?
No,
I only said that only.
on 21 past.
No, I say, read that. I said, I am giving them file time only till 21st. They have to file by 21st. I fixed the date on 21st. On that day, the court will proceed with that order,
They
giving
may
effect.
file or
to-
they may not file. That is defined.
That's their look. They have a right.
I-
It's a different thing. They may not. That's a
I'm
different.
also not aware whether amended external statement filed or not,
Get
but
an-
I have only this copy. I'm not aware whether opportunity was given
No, no,
or
it was
not.
not given.
You only say
But the written statement which I have received, that is.
because
not
now
amended.
there wouldn't there be an issue.
Lord, another issue will be whether the patta was indicated.
There may be an issue. There may be a thing that where they may raise the objection to that effect, maintainability in the respect to that prayer, taking into account 154.
Apply.
Sorry, in item number 4, Lordship has picked on 27.
Which one?
Item 4, I was on next.
Oh, yes.
Any date earlier next week, Your Lord. There I am paying for interim.
It is 27th is next week. Today is 20. Isn't or today is?
No, fine. There is a next Friday.
Oh, we'll have it on 20. 20.
I am difficult.
Yeah,
Oh, this matter.
yes.
Yeah, come.
The
Now
order
tell me.
dated 6/4/2024, my lord. In order
Which order you are challenging?
annexed 12, my lord, at page number 386,
Okay, tell me. This is an order of
mandatory injunction for removal of wall, boundary wall.
there are two orders. One is 29-4. What is the other one? 6-4. You are asking for 6-4.
6/4/2020.
What is 29-4?
After disposal of this mandatory injunction application, the plaintiff side has filed an application under section 151 for enforcement of this one.
Then
Then this 29/4 order was filed.
what does it say? OC.
419 page, para 14.
Now tell me.
My lord, before going to the
Who filed the suit?
plaintiff,
For what?
he filed a suit for, my lord, declaration of right title and interest, and thereafter for declaring plaintiff's right title and interest over the civil B land for Katha land, declaring confirmation of possession over the remaining portion of the civil A, except the land described in civil B.
No. He is asking for declaration of right and title and interest for entire schedule A land.
Yes.
And then he is
No,
asking for
B land, my lord,
Huh?
not A, B, civil B.
Then why is he asking for confirmation of possession of schedule B land or B land? Where is the plaint?
Then lordship will find page 29 onward.
What is the relief? Confirmation of possession over the remaining portion of declaration of right title interest over schedule B land, declaring confirmation of possession over the remaining portion of schedule A land, except the schedule B, recovery of So, Mr. Sharma, you have right over only 4 kathas.
I have purchased 4 kathas already.
But why you asking for confirmation of possession for the 1 bigha?
My lord, additionally, no, 1 katha, that also I have purchased, that I have also entered into agreement with one person with delivery position. Presently,
With agreement with whom?
with the original owners. I have the original owner had land measuring 1 bigha.
Is the original owner a party here?
Point party is not party there.
Then how can you ask for that?
So there we shall make necessary arrangement to count that regarding necessary amendment is made.
So that
Nah,
confirmation of possession of 1 katha, more than that, it doesn't arise.
That definitely we shall make amendment. We are making amendment application ready for that. But
That is
regarding
a different thing. But
that
as
is-
of now, that confirmation of possession of schedule A land the remaining portion doesn't arise as of now.
Mhm.
Because that person is not a party
No,
to the,
that is not
because
required.
if
At
you
this
give
stage,
a confirmation of possession, it will be just a right in rem. Yes.
that is not required. And that is, and that matter,
And what is schedule
that
D
land
land?
is not in dispute here.
Okay, what
They're
is
not in the
schedule D
dispute.
land? That is the one katha where you are asking for confirmation.
No, one katha that is not in dispute here.
No, what
Dispute
is
here is
schedule
the
D
land
land?
which I have purchased.
What is
Dispute-
schedule D land?
Schedule B land. That is
D for Delhi.
D. D is the land which they have forcibly occupied from us.
It's a part of schedule B.
Schedule B.
Schedule B is 4 kathas of land, so and so. What is the boundary? Length of 20, 1 katha. Okay, now explain me what is schedule B, C, and D land?
My lord.
Yes.
Para 6 of the plaint at page number 32. It says about the CDP land. Page number 33, para 6. That accordingly the aforesaid legal heirs of late Harmohan Das, namely Sri Subhachandra Das, Kundadhar, Pinoy Das, and Pinu Das, sold a portion of land measuring 4 kathas, covered by duct number so and so, KP photo number so and so, out of the Schedule A land, which is more specifically described in Schedule B hereunder, by registered deed number so and so, after obtaining due sale permission from the Deputy Commissioner so and so. Thereafter, my lord, para 8 of the same page, it says about the Schedule C, that is 1 katha, another land, that during the process of sale of Schedule B land,
Para 8 is that during the process of the sale of schedule B land, the plaintiff expressed his willingness to purchase the remaining 1 katha of land out of the schedule remand, and the vendors of the land also agreed to the proposal, and to their effect, accordingly, an agreement for sale to the remaining katha, 1 katha. So schedule C is outside schedule B.
yes.
That
So
is
B
clear.
plus C is equal to A.
B plus C is
Is equal to A.
now let
Now
us see
D,
what
my
is
lord.
D.
D, lordship will find at para 21, page number 38.
Taking advantage of the advantage. Some portion, no. Some portion. Where is schedule D? Sir, schedule D will be given earlier.
No, my lord. Here on.
So some portion he cannot say that.
For the first time reference is given in para 21. What is schedule E?
Who are the performer defendants? Who are the performer defendants?
Performer defendants are owners of the
That
land
one
adjacent
katha.
to schedule adjacent. They are the owners of land adjacent to Schedule B land in eastern side. In eastern side.
But whether Schedule D is a part of Schedule B?
Yeah.
No.
How do you say so? Where is the statement?
Well, my lord, one statement. Just
No,
to understand.
no. Where
Just
is
to
this?
understand situation. Just to understand the situation.
Huh?
Just to understand the situation.
No, not
Clearly,
necessary.
clarify the
Where is it in the plain that Schedule D is a part of Schedule B?
Yes.
Where? Show me in the plain.
para 21.
That is what Para 21 does not say anything.
Taking advantage of absence of plaintiff, the even of 1 to 4 enclosed upon some portion of duty land. Yes.
Because you are putting the boundary of Schedule D to the north is part of Schedule B.
Yes.
See the boundary of Schedule D. You are putting on the north part of Schedule B, but you are not saying there's no statement out here in Schedule D. Normally it is done. It is a part of Schedule B. So and so, of which one katha of the land
Yes,
is there.
Yes.
There is
But-
no mention anywhere.
Yeah.
Okay. Now we have understood what Schedule B. Now let us come. What is your case?
My lord,
Who are you? Who are you? You
I'm
are the
the
defendant.
defendant number 1, 2, and 4.
Ah.
So what happened here? The defendant number 3,
Ah.
he died prior to the institution of the suit. He died on 6/7/2023.
Okay.
Suit was instituted in the month of October 2023.
Hmm.
So some blanket sort of allegation is made against this dead defendant also in the plaint, in the injunction application, subsequently in the injunction violation application also, and in the mandatory injunction application.
So this person died.
Yes.
This defendant number 3 died earlier.
Earlier, prior to the institution of the suit. That's why plaintiff side has later on also filed an application for deletion of her name from the plaint as well as from the other miscellaneous application, and her name was struck out also. That
And
I have mentioned in my petition. Now, this very mandatory injunction application, my lord, it
no,
arises
we'll
from
come to the
order dated-
mandatory injunction. Will come to that. But first of all, how did the mandatory injunction come into being?
Yes.
Because
that
there
is
is
the
no.
order dated 6/10/2023.
Okay. Where is that?
Lordship will find from page number 153 onward.
153.
onward.
Yeah. Yes.
This is the ad interim injunction order file.
What is the ex parte?
No, we filed a caveat. So after hearing a verbal argument placed on that day, this order was passed. And I
What
want
is the order passed? In order to ascertain the result, the circle officer is hereby appointed as Amin Commissioner to ascertain the facts, to ascertain the total land of dark number, whether the land described in Schedule A is in possession of the plaintiff, whether the land of the petitioner enclosed by yard, the exact location and position of the land of the petitioner, as well as the occupier. Further, considering the nature of this court finds that there is an attempt of construction made over the suit property by way of the parties. If any permanent construction is completed, and so under such manner, this court finds that the subject matter of the suit which until the court decides the injunction. Status quo, as such, an order of status quo is hereby directing both the parties to mention property till the then 610 is done. So there was a direction in terms with order 39 rule 7 by appointing a commissioner for the purpose, and the second is an injunction of maintaining status quo as regards property.
so this order was passed on 6/10/2023. and there is an order for appointment of Appeal Commission. Now, coming to the impugn order, my lord.
Then what happened? Then they filed an order 39 rule 2A.
Yes, then this mandatory. Lordship, page number
Now, what is order 39 rule 2A?
that on 10/10/2023, we constructed boundary wall by violating the status quo order. Same is the case that is made out in the mandatory injunction application also. And now page number 405. Para number 32.
Wait. 405 will go. 6/10/2023. And what are these? Page 187, these are boundary walls.
Yes, they have annexed, my lord. So this is the fate of the Arming Commission that is mentioned in 32. There are 32, page number 405. In
So
addition,
they
the
filed
court
an
did not
application
consider.
under 151 for implementing that order means under status quo order.
Yes.
You see, this application which is being filed as Mize case number 1053 of 2023 is for implementing that order of 610.
610, yes.
And
Then injunction violation.
injunction violation is, this is an application under dismiss case has arisen out of a petition by paying to pass an order of adhering so and so from raising. There's another application on 610.
Yes, my lord.
Now this is the 610 same order.
The same order.
Is being repeated many times here. Now they file an application under 39 for grant of a temporary injunction. What are they asking for? So paragraph number 29 of this application at page 237 is the case of the plaintiff.
Yes, ma'am.
Then what is your reply?
My reply, Lord, will find at page number 277.
Yes, paragraph number 29, again paragraph number 29.
From bottom, line number 6, my lord. This para 22.
Page 277.
277. In this regard, from bottom number 6. In this regard, the answering opposite parties beg to state that from their perusal of the plaintiff document number 28, that is FIR dated 23/9/2023, lodged by the wife of the petitioner before the Commissioner of Police, inter alia stated that on 22/9/23, the right of way was blocked. But the petitioner suppressed the setback from this honorable court in his pleadings and for illegal gain, not only filed a present petition but also filed a violation petition against the answering opposite parties, including against a dead person. Under such circumstances, it is crystal clear that the allegation of violation of the court order dated 6/10/23 and construction of concrete wall surrounding the building of the petitioner on 10/10/23 by the answering opposite parties is a blatant lie, and the petitioner with malevolent intention has filed the instant petition only to obtain an order from this honorable court. It is required to mention here that the petitioner in para 25 of the plaint as well as in para 25 of the injunction application admitted that the opposite party is proceeding to execute permanent construction over the vacant land as well as is proceeding to erect concrete wall before filing of the present suit. It is quite interesting that in one hand the petitioner claimed to be a resident of Title A land, and on the same grade the petitioner stated about his visit over the suit land on 10/10/23 and found that the opposite parties has raised construction of concrete wall surrounding the building of the petitioner and thereby closed the petitioner's right of way. Although the wife of the petitioner has already stated that prior to the filing of the present suit, the right of way was blocked. The answering opposite parties beg to submit that from bare perusal of the document B. C and D. enclosed with the instant petition, it does not show that any concrete construction has been carrying out surrounding the land and building of the petitioner and planting any plants over the Schedule A land. From the facts and statements, including violation of the order dated 6/10/23 by a dead person, stated by the petitioner on oath, and the documents submitted by the petitioner before this honorable court, it is crystal clear that the petitioner with malevolent intention had filed a present suit just to obtain an order of injunction. As such, the petitioner miserably failed to make out a case for mandatory injunction, and the present petition is liable to be rejected. With regard to the statement made in para 29 of the petition, the answering opposite parties denied the statement made to the effect that the 3 number of vehicles which are now lying blocked inside without any access for movement are so-and-so bearing registration number so-and-so, so-and-so, so-and-so. As the said statement is totally false and baseless, in this regard, the answering opposite parties beg to state that the petitioner is not the registered owner of the aforesaid vehicles, and the aforesaid vehicles are not parked within the suit land and foreside boundary as described in Schedule A of the plaint. Furthermore, the petitioner miserably failed to submit any cause and document.
Okay, that I've got it. Then how is the, then why are so many petitions again? What are these? Written arguments. Okay, then where's the order? It seems to be a very highly contested matter before the trial court.
Yes, fine.
Yes, now, how does the trial court look into it?
386, my lord. About the Amin Commission, Lordship will find at para 32 at page number 405. In addition, the court did not consider the Amin Commissioner's report for lacking clarification on the points raised by the petition. So this report goes now.
Page
405, para number 32.
addition to the court did not consider the Your boundary is where?
My lord. My boundary,
Yes, give me that map now.
actually, what they have referred in the foreside boundary as the performance line, that is our. They are claiming that it is the performance dependent line. And in this impugn order also, there
Now
is reference to some
now,
lawsuit.
Mr. Counsel, who made that boundary wall?
My lord, para 29 of the plaint,
No, forget about 29. I'm asking you a specific question. Who made that boundary?
western side.
Western, eastern, wherever it is, does the plaintiff schedule B land? We are only concerned with schedule B. We are not concerned with schedule C.
Yes.
Whether the schedule B land is locked up in view of there being no ingress and egress.
No, my lord. No, my
There,
lord.
there is a way by right of way.
Yes, my lord. In the
Mr. Sharma, there is a
application,
right of way.
No, no right.
my lord, in the
have
application
done,
which
my
they
lord?
have filed subsequently under section 151 also, we have said that the building in the southern side is bounded by the National Highway 37 admittedly.
Hmm?
Building is facing towards the National Highway and there is a gate which is put by the plaintiff.
You
Kindly-
don't have a right of way from your schedule B.
For going to schedule B, I have no way. I know what is there. Highway is higher than the length, my length. So somehow by filling some length, I have made a way. I made a way. And there I installed a gate. What they have done on 22nd of August 23, they have forcibly entered into land. They have blocked that entire way on that day by some filling some materials, etc. At that time, there was no one. So, and thereafter, what they have done, they have removed my gate from that place and installed somewhere. And where the place where they have installed my gate, that is deep road. It's deep, quite deep. I cannot go there.
So what
Because
were you doing?
I am out of the house.
No. What were you doing? You didn't see all these things happening
I don't.
because you say that the order was passed on 6/10. You clicked photographs on that day. You say it in your paragraph number
16
29.
Order was passed. At that on that
You
day,
said that you clicked photographs. Then on 10th, when you went out there, you see that they have closed the entire boundary.
my lord, on 6th, the court has passed order for maintaining status quo. I was thinking that right, now the order of status quo is there, now they will not do anything. So I was thinking that I am not allowed, I cannot enter into my house. I cannot go near that place. I can employ someone to click photographs. I cannot go to personally photograph there.
No.
I
How
cannot
can
bear.
you? Were you staying inside the house?
No. I am not inside. I cannot go there in the house.
Earlier, were you staying inside the house?
Yes. Up to-
There's a house of the inside,
yes, my
and
house
it is it's boundary locked.
locked.
There's no way ingress and egress.
My cars are there. My entire house is there. Entire well furnished house along with all the groceries, everything. I have to leave the house. On 22nd of August,
Now,
that
who is in possession of Schedule C land,
should see it is by under my policy.
and what is to the west of Schedule C?
West of the street, see there are other person's land and houses, other person's land and house. Invest some other person's land and houses.
And what is to the north of Schedule B and C?
North again, there are other person's land and houses.
Huh?
Other person's land and houses, northern side. Southern side, there should be national highway, but national highway is much above my land. Only for going to my land, I have filled land, I have filled earth filling. After doing earth filling, I have made a way, made a road. I made a road there
Where?
to go to the Schedule B land. For going to Schedule B land, I somehow made a way by filling earth, and that way had been blocked by them.
But that is not your allegation anywhere.
No, they say that they have blocked my way, right to way. I cannot go to my house, my road.
No,
my
that is
own-
not your allegation anywhere.
which one, sir?
That road which you made by outfilling has been removed or was done by the.
They have
That is not.
removed-
That
they have
was
not-
that happened even prior to the filing of the suit.
prior to filing of the suit, they have forcibly entered the FIR. I don't know case is the FIR. The FIR which they are referring, my lord. The FIR is that the plaintiff had to, plaintiff was not there. He had been when the incident started, instead of taking forcible possession started, he went to police to inform about the incident.
No, that I've read it.
Therefore, while returning the police, while returning to home, he
Mr.
again
Sharma,
taken up
I have read those aspects of the matter.
Yes, yes.
I'm only asking you. It is not your case about you made a way from the national highway to your land,
that has been
and that has been removed. That is
No,
not your case.
highway has not been removed. The way has not right. No, my land has not been removed. They have enclosed that road. My case is that blocked that road. That was my access to my house. That was only access to my house, which they have blocked by.
Whose
Yes,
land
yes.
is that which has been blocked? Whose land it is? That area.
Our land.
So,
Schedule B
so
land.
are
they
you
have-
saying
they
that
have-
Schedule B is adjacent to the national highway? Means,
No, not adjacent. After.
so there is some way,
No,
there is some distance.
national highway and my road, there is some distance.
Yes, sir. Whose land is that?
That is government land. Government land. That is government land.
So what they are doing now is something in the government land.
No, in my land. My
In
Schedule
Schedule
B
B.
land, they have encroached about 1 kata 4 acres of Schedule B land, and while encroaching the land, they have now they have erected a boundary wall.
So this encroachment happens subsequent to the suit or prior to the suit?
They have encroached upon before filing of the suit. That is why we have prayed for recovery portion. But the boundary wall had been erected by them after the order of injunction. After the order of injunction, they have erected.
Earlier you didn't have a boundary wall.
Not, it is actually not boundary wall. It is only wall to encroach my land from the west, from the northeastern side. From eastern,
No, only one thing I'm asking you. Whether your Schedule B land on the west had a boundary?
not earlier there was no one.
So there was no
boundary
boundary on the west.
There was no boundary wall in the eastern side.
In the eastern side,
side.
there is no boundary.
There was no boundary wall. Actually, the eastern side, regarding eastern side land also, we had agreement with the original owners, but now they have encroached upon it. That is different issue. But while encroaching that land, they have also encroached upon our land, Schedule B land.
A portion of it.
A
1 kata.
1 kata 4 acres, around 1 kata. They have encroached upon it, and they constructed boundary wall in such a manner that I have no right, no encroach, no way to my house.
But why didn't you? A boundary wall can't be constructed over the night in this manner.
Huh?
Can a boundary wall be constructed in this manner over the night?
No, not over the night.
If you were staying inside,
No.
you were staying inside.
No. But I can say clearly. On 22nd August, they had taken possession of the land, including about 1 kata 4 acres of my land also. They have taken forcible possession of the land in place of in presence of police. They have taken possession. Husband was, the plaintiff was in police. They have detained me there. That is the modus operandi. That is the modus operandi of all the land grabbings. Husband is in the police. Wife is there and one minor child is there. They are inside. All night they are abusing them. They cannot go outside. In the FIR, I have mentioned that they have blocked my way out. Blocked money by human chain, by persons are standing there. They have some bamboo, etc. They have deposited there so that I cannot come out. All night they have tortured me. So on that day, they did not make any construction of wall. Thereafter, I have filed suit on 6th. On 6th, there was an order of injunction. On 5th, we have filed title suit. On 6th, there was order of maintaining status quo. Before that, on 3rd of October, on 3rd of October, no?
No, Mr. Sharma, one thing. No,
Mr.
Sharma.
There was no wall. On 3rd, there was no wall. On 5th, we have filed suit. In 5th, there was no wall. They have started some construction, etc. On 5th, they have started some construction. But on 6th, there was order of injunction. So, from on them onwards, such huge wall cannot be erected within one day. That cannot be erected because on 5th, there was no wall. On 6th, there cannot be such wall. So, it has taken time.
So they were going ahead with the construction as on the date on which you filed the suit.
Just started, just started.
They started.
Just started.
Did you mention that they were starting the construction of the wall?
Yes,
In your
just
plea?
somewhere mentioned that they are making some construction.
No, no, the
But-
wall.
At that time, we don't know whether there is wall or they are going to erect some
Mr.
building also.
Mr. Sharma,
My
Mr.
lord,
Sharma,
my lord,
Mr. Sharma,
no,
these-
they are
these,
making some construction.
these aspects are known
No, no.
and an experienced lawyer like
Yes.
you,
No, no,
you was the
I am
lawyer.
not going to suppress
Yeah.
anything.
No, obviously, that
That's-
I'm not saying.
There can be suppress.
I'm saying, did you mention out here in your plane at that point of time that on the 5th, they are trying to raise construction?
Some constructions are going. That is why we have had, that is mentioned. That is mentioned. First in plaint, permanent injunction from raising any construction.
Because as on that date,
Mhm.
on 5th, they started construction.
Yes, yes.
But your place, unless your land is in a very difficult area, as I could see, tomorrow if the government does not give you a road, you are finished. What will happen to 693?
Actually,
Unless the government says tomorrow that, okay, this will be kept reserved for as roadside.
mhm.
If it is kept as roadside reservation, it is okay, but you are otherwise in trouble.
In southern side there is government land, and we are made to think that that
How
will
much,
be-
how
that
much
will
is
be
the
road.
length from
There are other
your
persons called-
place from Schedule B to the national highway? How much is the length? So 100 meters, if it is there, if that is the entire is the government land, then it is a very serious thing. You don't have a boundary anywhere. But it belongs to somebody else.
Yes.
So where is your boundary? Where is your ingress and egress to your land?
Highway and Patadar. So highway is constructed. Bypass road. So after the Samadhi, it's very high. Road. And the government did not earmark the road on the revenue map. So now survey has been done on my research, and the road has been drawn on the revenue map. Now it is pretty clear, and that is why in between road and my duty land, there is another Nyadipata land which I had to, my wife had to procure that land. So it is now settled. That land is safe. And
So you have another plot of land which is in between.
adjacent to highway.
You have another plot.
But it is very high. It's about 20 feet,
below the highway.
more than 20 feet
Below the highway.
below the highway. So what do we need from the highway? We made a ramp so that vehicle goes down very slowly. So that land was that portion is open land. So we made that arrangement. We took permission from the DFDP and we made that arrangement. Lordship, on 22nd, they occupied that ramp.
The ramp also.
That ramp occupied. And evening time, I requested the police authority. Whole day police was there, but in front of police there were 150 people. So finally at the evening time, I called up the police headquarters, DGP, control, police commissioner, police commissioner, everybody. But I was not getting any support from the police. And evening time, Lordship, I went to police station to fight FIR and they did not help me. They thrown me one police station to another to SCP to this, that, everything. But finally, my wife and my son was suffering and they called me. I came back to
No,
home.
Mr.
I came back
it's
to home
okay.
and immediately I was taken
taken away to the police station stating that my security is in threat. And after got detained at that police station at 2 o'clock at night, I was so to say that give me your mobile phone, and go to the lockup locked. Immediately I went, and morning I discovered myself at DMC hospital. That is ICU or somewhere. And then I was paralyzed for about 1 week. And then
Now, tell me
they
whether
told-
this order has been complied with.
Not complete.
Okay. Who is appearing for the government? Yes, Mr. K. Bhattacharjee. Why you are not complying with this order? You are not a part. Call anybody who is appearing for the home. Ask Mr. PJ Talukdar to appear. Or yeah, we'll take it after some time. We'll see this order is complied with by tomorrow. Mr. Counsel, I'm not sorry. First of all, this raising of this wall business and all, if the trial court have already decided, this court is not going to touch it.
But my lord,
Not to that. I'm also directing the police by tomorrow to do it. And thereafter we'll see. Now, if the police does not do it, then we'll take up action. It's not done. Mr. Counsel, I have been also a civil lawyer for a long time. I know how it works. How the land grabbing mechanism
no,
works.
my lord, it's not a case of.
This is a land grabbing.
Our-
And
our- our
why,
is that we
whatever
inherited.
may be, it is a case why you have, whether you have a right over the Schedule D land.
Yes, my lord,
What right?
because my lord, the.
No, what right do you have? You have filed your request.
Yes, in written statement also we have said, we have inherited it from our forefathers,
Forefathers means,
my lord.
show me, what is the document of your right over the Schedule D land?
There is a gift deed, my lord, as well as a sell deed that we have mentioned in our pleading. In
Show
our
me
written
that.
statement,
Show me
my
that.
lord.
Where is the gift deed? You have enclosed many documents out there. Where is your gift deed?
They have not challenged our right over Schedule B land.
Huh?
They have not challenged our right over Schedule B land.
Is Schedule D a part of the Schedule B land?
321, my lord, from page number 321.
No, these are pleadings. I am not concerned with pleading. Pleading is not. Where is your document to show that you have a right over 691 or 693? Show me that.
691, my lord.
Where is it? And his right is on 693?
691 is a total land, out of which,
Your right is on which?
out of
690?
which in, yes, we are
lord.
presently in western side,
Lord,
1
may you
biga.
please to grant us some time, we will file it.
In western side, 1 biga, we are
We
having,
want to bring it on record, our title document. We have filed the written statement, but we have not filed the documents that we have delayed.
You have unnecessarily burdened with the court with all these unnecessary documents. We are not bothered. Your document, where is your document of title? And his document is of 691 and 493. Now it is new is 691. What is the total area of
My lord.
691?
total area of 91 is,
Page number
that is,
336.
Where is the Jamabandi? You must have enclosed it
yes.
somewhere.
it is total,
Huh?
1 biga, it was total actually 1 biga, 3 kata, 18, 1 biga, 3 kata, 18 letters total.
Okay. 1
Now-
biga, 3 kata, 18
18
letters.
But now, in current revenue report, it has become 2 kata, 2 biga.
How did
4
it
letters.
increase? How did it increase?
Perhaps they have some included some government land, etc. But actually, it is 1 biga, 3 kata, 16 letters. That was the actual area of land. Out of that, 1 biga, out of that,
Yes, madam, you are there for the home.
out of that, my lord,
We are fixing this matter on Monday. You just inquire as to why the government have till date, the police, which officer, Jalukbari PS,
Yes.
have not complied with the order dated 29/4/2020, passed by the trial. Because the direction was given to do it within 7 days. Why it has not been done? You just get your anger. Give him a copy, Mr.
Let a copy.
Give a
I want copy.
You want to file your document?
Yes, my lord.
Okay.
My lord,
We'll have it on Wednesday or Monday?
what is the my lord?
Wednesday. We'll have it on Monday, Wednesday. You file your document to the effect to show that you have any right over 691.
My lord,
691. And
my
in
lord.
the meantime, madam, you just get your instruction why the officer in charge of Jalukbari PS have not complied with the order dated 29/4/2024 in Mizek. We will see. Today, let them break it. Tomorrow, we will look into it as to what protection can be given to you later on. But this order needs to be complied.
My lord, I
my
have,
lord.
my lord,
about
I have supplied the map.
documents.
My lord, I have made the test map, my lord. One test map has been given by my lord. In the test map, my lord, I have shown that Schedule B land, and in the eastern side of Schedule B land that is the land which they are claiming to have right and title. That is the land which they are claiming, not my Schedule B. They have not challenged my schedule of Schedule B land. They have not changed my schedule. So Schedule D is the part of Schedule B land. So although they are claiming land in my same Dagan Patta, but that is different land. That is in eastern side of my land. That is eastern side of my land. That is another thing. But my land is Schedule B. Out of that, we have to.
In the written statement, have they challenged your title over Schedule B? No.
No, not challenge. They have not challenged.
My lord, in page number 328 in our written statement, we have give reference to this deed deed and the registered sale, which is of the year of 1950.
Maybe. But whether that includes this land?
Yes, my lord. There the question lies. That's why the learned court issued one Amin commission to ascertain those aspects. Actually, who encroached whose land?
And where is the Amin Commission's report?
My lord, that is discarded by the as per the
Understood. Where is the Amin Commission's report?
That is here, my lord.
Give it to me.
Yes, sir.
and on the last occasion, learned court also expressed his mind to issue one fresh Amin commission.
We'll look into it. You just take it out. Huh? I'm coming in 5 minutes.
My lord, we will also file the Amin commission along with our document.
What does it say, Mr. Sharma?
My lord,
What does it say?
Min Commission report says that they have occupied 1 cut of 4 acres of my land. It clearly says that they have occupied 1 cut of 4 acres of our land. My lord, my lord, on last page of the report, my lord.
There are two NOCs for purchase or one NOC.
My lord, one is the NOC obtained from the receive office, one is the NOC of the TMDA.
But as per NOC, sale it was not accepted. It is also written in the report.
Now, if you see this particular map, see, this is the
Last page of report, my lord.
now
that-
kindly come to the map which has been drawn now. There, this is 691. The entire tag is 691.
Yes, ma'am.
There it is 3 Katha 16 lectures.
3 kata 16 letters each up to this person.
As per the report, he is in possession of 3 Katha 16
16
lectures.
letters.
But he has not taken into consideration one more Katha which is there of Schedule C.
That is mentioned by him in last page. Last page of report. মানে ইয়ার উল্লেখ থাকে যে প্রথম পক্ষ দাখিল করা দলিল সহজ মতে এক কটা চারিলতা জমি দ্বিতীয় পক্ষের দখল দেখা যায়।
No, that is what he states in his plaint. That is what he says. It is not his finding.
In the report.
What does he say here? উল্লেখ থাকে যে প্রথম পক্ষ দাখিল করা দলিলৰ means as per his contention, it is 1 Katha 4 letters he is short of it.
And as per my cell lead, I have to be 4 kata of land, but out of that, I have been found in position of lesser land. And 4 kata
4
plus
lesser
one
is less. 4 lesser
1
is
kata 4 lesser.
no.
No, one entire land, 1 kata I have given Schedule A, Schedule C, for which I have entered into agreement and taken delivery of position Schedule C, and Schedule B includes 1 biga. Out of that 1 biga, I have been found in position of 3 kata
16 lesser.
3 kata 16 lesser. I have found in position.
That is what I say.
I should have
That
been
is what I say. I'm saying. This report takes the consideration of your possession on the basis of Schedule C land and Schedule B land together.
Total.
And therefore, it is 3 Katha 16 letters without taking into account that one big Katha of land, which is the Schedule C land. It does not belong to you. It is yet to be sold to you.
1 kata. If 1 kata is reduced, then I shall be in position of 2 kata 16 letters. 2 kata 16 letters of my 4 kata of land.
Now, did you file an application for cross-examination of this witness?
Actually,
No, ma'am.
actually, nobody has filed till now. Nobody has filed any objection, etc. Nobody has been filed. That is still.
Why?
Actually, the court is considering that the trial court was of the view that since I have on my own call for the record for just my perusal of my clarification of the matter, it is now under order 26. So trial court was of the view that
The moment it is done under Order 26,
yes.
If it is construed to be done under Order 26, don't you have to file an objection if you want to cross, if it goes against you? Because this record
want to say
will be an evidence for all time to come.
court want to say that it is under order 39.
The court cannot reject this.
Yes.
In view of the Silchar Municipal Corporation judgment, the Silchar, this
Definitely,
court cannot reject it.
we can,
This will all along remain in the record.
definitely. But still, it is under process. We can still file objection there at this time also. But one thing is that court has found that the Amin Commissioner also found that they have occupied. Amin Commissioner also found that they had occupied my land.
4 lesser.
1 kata 4 lesser. My lord, 1 cut 1 biga.
Where is that Amin Commission's report to say that 1 Katha 4 lesser they have? No, it is not there.
My lord, Schedule C is, there is no dispute regarding Schedule C at present. Presently, they are occupying from eastern side. Eastern side is the land.
Where is it mentioned in the Amin Commission's report that the Amin Commission found that they are in additional possession of 1 Katha 4 lesser?
My lord, the drawing,
There is any method
my
of
lord, the
boundary
drawing
wall.
shows, my lord, the drawing shows that is the point. That is the drawing.
That is what I am saying.
That is the,
Understood. All these things are understood. Therefore, wasn't it
Yes,
necessary or incumbent
everything-
on you to
yes,
file
sir.
that application?
definitely, your right
Well-
pointed that definitely Amin Commissioner has to be cross-examined.
Yes.
Definitely. That
Because this way, either, you see, there are two options. Either you ask for cross-examination. If you ask for cross-examination, the Amin Commission will come up. The court may not satisfied, may issue another Amin Commission, but the court cannot do so because this will always be a part of the record, and without a cross-examination, it would have far-reaching consequences on you.
Definitely. It has to be clarified by cross-examination which portion has been encroached upon.
Because what is the next land thereafter?
Uh-huh.
After 691, as per the revenue map, what is the next land on the western side? Or is it still 691?
After 691, there is 697.
So the next is 697. So 691 consists of Schedule C, Schedule B, as well as some portion of his land.
That is disputed between pro forma defendants and him.
My lord, the total quantum of land containing in 691 is also disputed on the very first by us.
So as per you, it is 2 bighas.
Yes, my lord.
So
That's what-
therefore, he says some portion is his. 1 bigha is yours. 1 bigha or whatever, 4 kathas, and there is another 1 katha of land.
Yeah.
Problem arises, you have not made that person a party, which you should have made. Those from whom you are going to purchase, they should have made the performer defendant most essential.
Actually,
You cannot ask for the declaration for confirmation of possession in respect of Schedule C land unless and until you have made those people a party.
In fact, Schedule C land could not have been mentioned here. There should be Schedule B land only. There should not, in the case, Schedule
No,
C
you
land should not
mentioned
have
it for your
been mentioned.
clarification that you are in
Yes.
additionally in
Yes.
possession on the basis of some 53A or whatever maybe you are in because there was a
That
delivery of
clarification
possession.
should have been there, but in prayer portion there should not be anything regarding Schedule C.
Nothing, you could not have.
Should be also only.
You could not have.
Ah.
So under such circumstances, this particular portion of land, Schedule B,
But regarding Schedule C, separate suit has been filed by the vendor against us. That is also pending,
by the vendors against you. Why?
claiming their right of land interest. And
That will be
withholding
your land.
Yes, they are.
No,
the-
not that land. That can't be against you because you have nothing to do with Schedule C land. Schedule C land is on the other side of here, west of Schedule
My
B.
lord, we will bring everything on record. Let us be given an opportunity to file an affidavit. The suit filed by the vendors as well as this Amin Commission report and our tax.
Chalo.
That is different.
We ask them why they are not complying.
Yes.
The instant petition appeal has been filed. Heard Mr. Swenso, the learned counsel appearing on behalf of the petitioner. Appellant, Mr. S.J. Sharma appearing on behalf of the respondent.
Yes.
Other respondents are there?
No,
No,
Only-
no, only one. This is an appeal filed under Order 43, Rule 1R of the Code of Civil Procedure, challenging the orders dated 6/4/2024. You are challenging the next order also, 29/4? No.
ma'am. Right
No.
now, there is no.
Order dated 6/4/2024, passed in Mize case number 1052/2023, arising out of title suit number 61/2023, 619, whereby the learned trial court issued a mandatory injunction directing the petition appellants herein to remove the boundary wall from the front side of the building of the petitioner and open up the right of way for free movement of the petitioner through his vehicle for ingress and egress to his building standing over the Schedule B land, which is a part of the Schedule A land. The appeal is admitted, taking into account the various disputes. This court takes up the matter, would be further taking up the matter on 24th of May. 24th is open, na? 24th of May 2024. In the meantime, the petitioner herein would be at liberty to bring on record other documents, including their document of title over the land, if any. taking into account that the records are all there is no question of this court is not inclined to call for any further records. You filed an IA?
Yes, ma'am. 1421. I have.
Good, yeah. This is an application filed under Order 41, Rule 5 of the Code of Civil Procedure, praying for stay of the proceeding and operation of the order dated 6/4/2024 passed by the learned Court of the Civil Judge Senior Division number 1, Kamluk Metro of Guwahati in midday case number 1052/2023, arising out of title suit number 619/2023. This court, upon perusal of the materials on record, does not find any good ground for the purpose of staying the impugned order dated 6/4/2024 passed by the learned trial court. This court have also taken note of that there is a further order passed on 29/4/2024 by the learned trial court being missed in midday case number 383/2024, arising out of title suit number 619/2023, wherein there is a direction to the officer in charge of the Jalukbari PS and the civil Nazir to enforce the mandatory injunction order dated 6/4/2024 passed by the learned trial court. The officer of the Jalukbari PS along with the civil Nazir was directed to enforce the order dated 6/4/2024 within 7 days by removing the boundary wall from the front side of the building of the petitioner and open up the right of way for free movement of the petitioner through his vehicle for ingress and egress to his building standing over the Schedule B land, which is a part of the Schedule A land. However, in spite of almost 24 days, this is the 6/29, in spite of the period being over, till date, nothing has been done by the officer in charge of the Jalukbari PS in this as regards the compliance to the order passed by the learned trial court. This court have requested Ms. D.D. Borman, the learned additional senior government advocate, to apprise this court on the next date as to why no action has been taken by the officer in charge of the Jalukbari PS on the order dated 29/4/2024 passed in midday case number 393/2024. A copy of the order be furnished, of the instant order be furnished to Ms. D. Borman, D.D. Borman, the learned additional senior government advocate, for due notice for necessary steps to be taken, and also along with a copy of the order dated 29/4/2024 passed in midday case number 383/2020. Get your information on why it is.
Para 3 and para 4.
When is the next date fixed in the trial court?
16/6.
16?
6.
It can't be 16/6.
6. I'm sorry. 6.
Notice. appeal to the notice. This is an appeal filed under Order 43 Rule 1R of the Code of Civil Procedure, being aggrieved by the order dated 18/4/2024, passed by the Learned Court of the Civil Judge Senior Division Number 3, Kamrup Metro at Guwahati, whereby the Learned Trial Court it had only issued notice but did not grant the ad interim ex parte injunction, thereby fixing 6/6/2024 for service report as well as for written statement. Service report / objection. In Mizze case number 357/2020. The appeal is admitted. Nah, we won't admit the appeal. Let notice be issued, making it returnable on 19/6/2024. Steps be taken by registered post as well as usual upon the respondent in addition to that, the petition appellant is also directed to take steps to the stay rooted to the registry of this court and file an. Oh, why are you making these people from Arunachal Pradesh? What are they doing?
They are the performer responsibility. We have purchased the land from them.
Who is the main defendant?
1, 2, 3, 4, 5, and 6.
So, what is defendant number 6 doing? He is in Arunachal.
Yes, sir.
How is he disturbing?
So he's man and agent, sir. We came to know that he is also one of them. Yes. Yes.
In addition to that, the appellant is directed to take steps by way of the stay rooted to the registry of this court and file an affidavit of service on or before the next day. This is an application under Order 39, Rule 1 and 2, read with Section 151 for grant of an injunction thereby restraining the opposite party number 1 to 6, their men, attorneys, agents, assailants, etc., from entering to the suit land and from disturbing the peaceful possession of the petitioner over the suit land till the disposal of the appeal. The case of the plaintiff herein, the petitioner herein, is the petitioner is the owner of a plot of land measuring 3 kathas 12.5 acres of land. 12.27 letters of land, equivalent to 9.63 R. Covered by various darks in KP Patta number 622 of village Porusora under Moda Beltola in the district of Kamrup Metro, Assam. It is the case of a plaint petitioner that the said food land upon being purchased by the registered deed of sale bearing deed number 927 dated 18/1/2022. The petitioner was enjoying the possession of the said food land. The said food land by erecting boundary walls. However, on 3/4/2024, the defendants and their hired goons had broken and fell down a small portion of the southern side boundary wall. However, with the intervention of the police, the defendants could not, or their agents could not, dispossess the plaintiff. It is also the case of the plaintiff petitioner that the defendant number 126 as well as the agents are trying to snatch away the possession of the food land from the plaintiff. And as such, taking into account the acts of the part of the defendant, a suit was filed being title suit number 195/2024 before the Court of the Civil Judge Senior Division number 1, Kamrup Metro at Guwahati, seeking declaration of the right title and interest over the Schedule A land, a permanent injunction restraining the defendants numbers 1 to 6 and their men, attorneys, etc. from disturbing the peaceful possession of the plaintiff over the suit land, as well as issuance of a precept to the concerned land revenue staff and circle officer to demarcate the land of dark number 316 and 318 of KP Patta number 622 of the suit land vis-a-vis the land of dark number 315 of KP Patta number 628 situated near the suit land. Along with the said suit, so filed an injunction application was also filed which was registered and numbered as Ms. J case number 357/2024, seeking a temporary injunction restraining the opposite party therein from disturbing the peaceful possession of the plaintiff over the suit land. In the said application, it was categorically mentioned that the plaintiff's possession over the suit land is under great imminent threat, and there has been and as such sought for urgent relief by waiving the mandatory notice under Order 39 Rule 3 of the Code of Civil Procedure. However, the learned trial court, by the order dated 18/4/2024, on the ground that the police authorities are duly investigating the matter, police authorities as well as the circle officer are duly investigating the matter, did not find that there was any imminent threat to the possession of the plaintiff over the suit land, petitioner over the suit land, and as such did not grant an ex parte injunction, thereby fixing 6/6/2024 for service report and written objection. It is under such circumstances the accompanying appeal was filed, being FAO number 33/2024, wherein this court today have issued notice. It is also relevant to mention that an additional affidavit has been filed by the petitioner, bringing to the notice of this court that even after rejecting to issue notice, even after the order dated 18/4/2024, the petitioner have received threat as regards dispossession on 21/4/2024 and 5/5/2024. This court, taking into account the above, is of the opinion that pending notice of the instant appeal, there is a requirement of the requirement of protecting the interest of the parties, interest of the parties to the suit, insofar as the possession of the suit land is concerned. So, taking into account the threats which have been mentioned in the affidavit, additional affidavit filed, this court is of the opinion that this is a fit case for waiving the mandatory notice under Order 39 Rule 3 of the Code. Else the filing of the accompanying appeal would become infructuous. So, taking into account the above, this court therefore directs that both the parties shall maintain possession status quo as regards the possession of the suit land, which have been specifically described as Schedule A to the plaint of title suit number so and so. Number, what is that title suit number? 195/2024 till the next date. It is further made clear, Kusal, this court have also taken note of that the suit is fixed on 6/6/2024 along with the injunction application. Kusal. The instant proceeding as well as the order passed herein shall not be a bar on the part of the learned trial court to proceed with the injunction application. However, the above injunction order shall be maintained till the disposal of the injunction proceedings.
I'm deeply open.
Before the trial. When notice is here also dusty service law bole bote yaar apne notion etu to notice issue koi di I to notice making it turnable by yaar dusty service steps during the course of the day date it be that steps during the course of the day and dusty service you started today and file it during the
Item 8.
yes what is this
Against the state judgment and degree, my friend also filed another appeal. Here.
Huh?
My friend also filed an appeal against the same judgment and decree. Let this put the matter take together. I also appeared in that case.
you are the
I am the respondent in that case.
so what first you have to prove here something yes tell me
The originally I
did
filed
this matter come up 2 days before
for
and I said that I am not satisfied. Then you
No,
said
no,
that
it-
let the matter come up with the other matter. Is this
no,
the-
no.
There is another one.
So, they filed another.
You are the counterclaimant.
My lord,
You are the
I am the plaintiff.
okay. Your suit was
My suit is that I purchased some land and I allowed the defendant owner to decide for temporary basis as on their request for 3 years. That after
permissive.
permissive way. So they requested me that another judge may that we allowed them to. But lastly they did not so what they tried to do the way. So I filed a suit. My suit was dismissed because although I said that I purchased the land, he could not put it on registered sale.
You didn't have a registered sale deed.
But
Okay.
he said there is a registered sale deed.
Huh?
Registered sale deed he purchased. He said now he has he is not in the position. That school deed is not in the position. So I thought with this.
No. You had a registered sale deed.
Yes, they say
Who say?
plaintiff.
But
But
then
they could not exhibit it.
okay. Then
So ultimately suit was dismissed. I think suit was dismissed.
then
Then I filed an appeal to this.
then
And they also file a counter claim against the suit. It's a counter claim. Is partly allowed.
what is the counterclaim for?
Counter claim that they claim the whole property of X and Y in their counter claim.
From
From my position.
you are in possession.
Yes, Y. And in the Y is total land. So there is a total land.
So that counterclaim they have already that is also dismissed.
That is also partly allowed.
So they have filed a second appeal.
They filed the appeal. Appeal also
Same order.
They also filed an appeal.
So now they have come up in a second appeal,
Second appeal.
which has already been admitted.
Not
Not admitted.
Question frame, substantial question of law frame.
So
in a different
admitted.
context.
Now you say why the court was wrong without having a deed of sale, registered deed of sale. Why didn't you call for the document?
That is there, but they could not. They did not done it. My lord.
No.
So
We dismiss it.
there is only pending, and moreover, people also kindly see.
No, you are asking for right title and interest.
Yeah.
So you have to show your right title and interest on the basis of a document of title.
Right.
You did not produce any document of
Yes.
title.
Yes.
explain what is wrong.
So far it is related to so far Schedule A property.
Huh.
And in their counterclaim, they mention Schedule A.
We are
and
not
Y.
concerned with the counterclaim. We are only concerned with, there's no, the plaintiff has no, the exhibited not any document. Plaintiff exhibit certified copy of the Jamabandi, revenue receipt. These are documents you have produced. Jamabandi.
Even then, they did not exhibited any
Let us see how does the trial court look into it.
case 33.
The defendants are the sons of are the legal heirs of Devendra and Jyotindra Sarkar, who are sons of Jadu Namodas. And admittedly, the Pattadar is Jadu Namoda. And you purchase from somebody else.
So we purchase Devendra Sarkar,
Monindra Sarkar,
Monindra Sarkar,
Sachindra
Sachindra
Sarkar,
Sarkar,
and Jyotindra
Jyotindra
Biswas.
Biswas.
How does they, who is Jyotindra Biswas?
Jyotindra Sarkar is the son of Jadu Namut.
Huh?
Jadu Namut.
Jodu?
Jadu Namut. Original partner.
So you accept that the defendants are the successor in interest of Jadu Namodas?
Namodas.
Do you accept or not?
Yes, yes, it is mentioned. It is also clearly mentioned that
No, it is okay. I am asking you.
Namodas, his two sons, Devendra Sarkar and Jyotindra Sarkar. So Jyotindra Sarkar, one of them I purchased. They are
Purchased by an unregistered deed.
Jyotindra Biswas.
Unregistered deed.
Unless they say what I find here, he mentioned that the registered deed. But it does
Who
not
mentioned?
mention. Appellate.
Where?
Paragraph,
No, if you don't produce it,
my lord,
let us see
paragraph
what has happened.
12b, paragraph 12b, page 14.
Okay. Well,
That modern paragraph 12b, Schedule 1 modern pictures evidence show that he purchased the title by registered sale deed, but he does not have it. But now you lost the calcium, it is page 13, paragraph 13. We got the mention that both the football has did not disturb our mutation matter. They say it is finality. It is final.
No, for you to get a right title interest, it cannot be on the basis of mutation. It's a different thing. You may succeed in the counterclaim against him. It's a different thing. But as of now, how do you get a right title on the basis of mutation? And what are your substantial questions of law? Perverse, not pervert. Suffers from perversity on a misinterpreting, nothing is there. Counterclaim is required to impede the other parties. Yeah. We are not concerned with the degree of the counterclaim. Are you challenging the degree of the counterclaim or your dismissal of the suit? Which one?
The counterclaim. Yeah. It is counterclaim.
This appeal is against whom?
Counterclaim.
Not against the dismissal of your suit.
It should. It is. I filed another suit. It does not.
Huh?
I filed another appeal also. But it is. There is some defect. It does not.
So you file another appeal.
Another appeal.
When?
Against dismissal of my. And it is filed. They are counterclaim allowed. They also file an appeal. First appeal my lord. And against that their appeal, we also file.
Yes, what is your
Yes,
number of your claim appeal?
Lordship,
What is your number?
I say 101/2022.
RSA
101/2020.
2022.
Yes.
And your defect is there's, I think there must be a delay.
Yes, delay.
How much?
It was already. It is already condoned.
Not here, the other one.
Other one, my lord, there is. I found there are some. Domain number 5 expired. I filed substitution petition. Here also filed substitution petition.
Where is the other defective appeal?
I filed.
What is the number?
Appeal is not number.
I is number.
I is number.
Yes, where is that?
130. 130 2022.
List the instant
And
appeal.
but
List the instant appeal along with RSA number
101/2022.
10/2022 and IA number
130/2022.
130/2022.
And IA number 2315/2019. In RSA filing number 3650/2000. But
On
only difficulty, my lord, I take the order, but suddenly it is mistakenly it is mentioned that I put on the IA. I am now today I take it. I surprised. There is some mistake.
don't worry, we'll finish everything together on one date. We'll finish, the date is on 30/5/2031. 31/5/2024. We'll finish all the 30. 3 appeals will go. 35/2020.
Obliged.
This appeal goes against the counterclaim, nothing is.
And that also.
Lord,
Yes, what is this?
Lord, appellant number 1 being defendant.
Hmm?
Appellant number 1 being defendant. Lord, sold 1/3 share of his land to the appellant number.
Where are your substantial questions of law?
My Lord, that of course I haven't framed, but my Lord, there are 3 substantial questions of law. One
Where?
is whether land already transferred by a registered party prior to the filing of the suit, my Lord, can be subject matter to be scrutinized under section 22 of Hindu Succession Act. This is number 1. Now,
Where are your substantial questions of law in your memo of appeal? Isn't it the requirement?
it's the requirement.
Then we dismiss it on that. Matter ends.
My Lord, do one thing.
Hello.
Let it be posted the next week.
The form appeal is not in the form. So
That I have said, my Lord, that is not there.
then appeal is valued at 20,000.
The lordship may do the same on merit.
Huh?
The next, Lord, next week, Lord, fix it. That could have been, Lord, next in the second.
Where is that? Here. Your plaint is here.
Plaint is there. Plaint your lordship will find.
Who are you? You are the plaintiff?
I'm the defendant.
Defend number?
Defendant number
1 and 2.
one and
Nirudas
Met.
and Aklu.
Nerudas has sold to Aklu.
So you are paying for both. 1 and 2. What is the plaintiff's case?
Plaintiff is they want to say
Decree be
that
passed declaring 1/3 share
Well.
each of the plaintiff defendant by right of inheritance. Who was the owner of the property?
owner, my lord, both Nirurani Das and plaintiff Krishnan Das.
Plaintiff Sushil Das were owner.
Both of that by inheritance, my lord, they have got 1/3 share. So, my lord, the claim of the
He was the
plaintiff
son and you were the daughter.
daughter.
Okay, then
Now, plaintiff claim is that the defendant number 1 would have given the land to him by virtue of right of preference under section 22 of the Hindu section. And since that
right of
was
preemption.
preemption. Now, my lord, there are evidence by both the sides. Both the court did not believe our evidence and they accepted the evidence given by the plaintiff. Therefore, my lord, ultimately both the court shall decree against.
Hindu section.
Lordship may see section 22.
Yes, what is your substantial question of law?
But I have written it, but my lord, I'll type it out and I'll find.
No, tell me. You have
So,
already
number
spoiled
one
so.
is whether land already transferred by registered deed prior to the filing of the suit by the appellant number 1 to appellant number can be subject matter is 22 of the Hindu Section Act.
Or in other words, whether a transfer by one of the legal heirs prior to filing an application under section 22(2)
Exactly.
would be void.
Right.
I think that is,
Yeah, that's the question.
I think that is it. I don't think anything more than that.
That's enough. That's the precise.
not much fancy. I had Mr. S. Datta, the learned senior counsel, assisted by Mr. H. Pura Kumar, the learned appearing on behalf of the appellant. What is the direction by both the court?
So your lordship may see at page. The appellate court judgment, your lordship will find last page 34.
Issue number 2.
My lord, after
How is issue? We are concerned with issue number
issue
2.
number 2, your lordship will find that at page 31.
Schedule 1 line is an agriculture. The advocate for the respondent submits agriculture will not come under the purview of the land council. There is no conflict.
It's decided that some other high court, both the side there are decisions.
This is an agricultural land.
Agriculture. And it's admitted.
Kindly come to page 31.
Yes.
We have gone through the said judgment and decision was based on the concurrent list, state list in the Article 246. But in a decision reported in AI 1994, Bombay, it was held that Section 22 of the Hindu Succession Act is applicable to agricultural land, save and except to the extent provided in Section 4.2 of the Act.
Well, there's some other decision has said otherwise.
Overriding. Save it. Where is it mentioned that the agricultural land would not be?
So this is the decision cited in year 91 Rajasthan 16. The lordship has said that agriculture will not be covered by section 20. Then again, Mumbai
Why?
has said otherwise.
No, why?
That's of course the decision they got verified also.
Yes, thereafter, if you read Section 22 of the year, which is omitted with effect from 9/9/2005, runs as follows. What is this?
It is omitted. For the removal, it is hereby declared that nothing contained in this act shall be deemed to affect the provision of any law for a time being in force, providing for the prevention of fragmentation of agriculture ordinance or for the fixation of the religion of that. Therefore, my lord,
This is, I think,
after
this
2005,
provision has been explained in Mullah. Sometimes say that this act does not apply to an agricultural land, but that would not be a correct proposition. However, they would relate only to certain specified lands by various states and armed for influence. What is this he's referring to? I'm not getting 1 and 2. Where is 22C again? 22?
23 as such, it is not there. 23, 1, 2, 3, then explanation.
Now, the judgment of Guwahati, AIR 1994, Guwahati 88, that goes against the question which you are.
So let me,
Because here it says the right is already there. Which comes the moment a person dies, the right is already there. If that right is there, you exercise anything, whether you file an application or not, doesn't apply. So there might be a case of poetry and all, it's a case of part. Here, in this case, in that we are apparent violation.
as such, your lordship will find the right of preference which piece of legislation. Now, here they say that I wanted to say land to him, a certain consideration. But my lord, my evidence is that I never uttered all that. I wanted to sell, but they never came forward. So
But did you
both
give
of-
evidence to the effect?
both versus both now here.
No, no. Did you give evidence that you wanted to sell it to him?
My lord, that evidence. Now, on the
Because
basis
there is
of-
no discussion anywhere, anything to
No,
the
no,
effect
your
that you
lordship
wanted to sell.
Your lordship will not find all that here. Now, abruptly they have gone, and even
What is your basis to say that you gave that?
now,
Because the trial court judgment, first appellate court, it does in the case of the. Now you must have stated in your pleading, in your written statement,
pleading
you
to
can't
in
give
the
your
written
evidence
state-
that you.
Yes, in the written statement, your lordship find.
What did you say?
Your lordship look at paragraph page 45. Paragraph 13. We have denied here, then actual aspect you lordship find at page 47.
Now, what has happened in respect to this cross? You must have given similar evidence to what you have stated at paragraph page 49D. Do you have your copy of your evidence?
Lord, you lordship take some other date. Lord, I look into.
Because otherwise, this I don't see the trial court or the first appellate court not touching on that aspect. Where
court is
offered to issue number 4. How does the issue number 4 is decided? Now let us imagine here the plaintiff thereafter asked searching for money, and on his request to answer expressed his willingness to help the plaintiff in the final, and when he was waiting to purchase the land, he learned from his daughter that the defendant number 2 Akumia, that his brother and some other person trespassed into the land, and when the objection was raised, they assaulted the family members and thereafter case. The plaintiff, and it appears that the defendant number 1 advanced the proposal to sell. From the plaintiff, it appears that the defendant number 1 advanced her proposal to sell her share to the plaintiff. The legal position in our case is that it is the duty of the defendant number 1 to show that her proposal was refused by the plaintiff on the ground that the plaintiff was no need of remand and he was in want of money. The defendant number 1 stated in her evidence that when she advanced the proposal to sell the land, the plaintiff refused to purchase the remand, and plaintiff told her to meet another sister remand for purchasing the land, and according to the defendant number 1 met the daughters of Hirubal, but they also expressed their honor. The defendant did not produce the daughter of the remand. So there is extensive evidence to the fact that the plaintiff refused to purchase the defendant sale. The defendant is the daughter of the contempt of the he produced another whom he got to offend. In his talking terms stated that he can take the defendant number 1 met the plaintiff and expressed the willingness to sell the and there is no insistence of lending money to the plaintiff by him. One for evidence and number is a trial court judgment.
That page starts from page 8. You know, but either page 12.
Issue number 4 and 5. The two defendant number 1 offered to transfer to the plaintiff. Don't you think a case of perversity is there? You see, if issue number 4 goes this way or that way, that's the answer to issue number 2. Didn't?
And furthermore, my lord, will also be fine. No issue frame in regard to how they have acquired, the plaintiff has acquired right of preference.
Right of?
Right of preference of purchase of the.
No. That is not issue. There is no denial to that because you also say in your written statement that we have given the offer. So that is not there. But this issue number 2, issue number 4, whether the plaintiff number 1 has so and so. So issue number 4, dependent on issue number 4, issue number 2 would be decided. Now, issue number 4, trial court, I think didn't decide it properly.
2 and 4, your lord, will fine.
Kindly see page 15, 1-5.
While deciding issue number 2 was held that the plaintiff in fact offered to plaintiff that the plaintiff showed his willingness to accept her gift. I don't know from where gift.
Now, kindly come to page 14. The burden upon the defendant to prove that she did offer to the plaintiff sale and the plaintiff did not accept her proposal.
Page 40. The burden upon the defendant to accept the offer says and the plaintiff did not accept her proposal. In view of position and her acceptable evidence by the side, the evidence of the defendant cannot be accepted.
Now, what burden can a person give? We'll hear it again at 2. What burden a person can give? The court comes to there is a discussion. In case both the parties admitted the fact that there was some discussion. Now, if there was some discussion regarding the proposed sale, so there is some discussion. If there is what is the burden required to be proved by him that how? By writing letters? Or is it by written? We come at 2.
Defend number 1.
Hmm.
It makes the thing entirely clear. How may both the courts have ignored the evidence? Right. Defend number.
Yes. Because the other questions which I was supposed, on the question of agricultural land, it does not arise. Because of the fact that inheritance comes within the ambit of entry 5 of list 3. And as such, 22 comes into the picture.
Right.
And this being a right, having nothing to do with tenancy, also 4.2 earlier had no relevance. On the question of limitation which you have stated, that would also have no relevance, taking into account Article 97 of the Limitation Act, which categorically gives 1 year for claiming the right of in. Yeah. Yes, what is that?
Lord, you Lord, to see that we have offered to them and they have said that they are not financially they are not in a position to partake. So all these evidence, my Lord, has been ignored by both of them.
Where is it?
It's Nehru Rani, your Lord, with my type. I have marked it.
Now, what does the plaintiff say
Plaintiff
on her
says-
cross-examination? She must have been cross-examined.
Yes. And if you look at the finding, the finding is that defendant did not offer for party.
Hmm?
That is the finding of the learned court. The
No,
defend-
the finding of the learned court is the burden upon the defendant to prove that she did offer to sell and the plaintiff did not accept her proposal.
That pardon we have discharged by reducing evidence. And the court did not accept that.
But can you adduce that evidence to the effect?
My lord, if they want to say that we are ignoring that evidence, this leads to a perverted.
This is in Bengali.
Yes.
Heard Mr. S. Dutta, the learned senior counsel, appearing on behalf of the appellant. It's an appeal under section 100 of the Code of Civil Procedure 1908, challenging the judgment and decree dated 9/2/2012, passed by the learned civil judge number 2, Kachar, Silchar, entitled Appeal number 22/2006, whereby the judgment and decree passed by the learned trial court, that is the dated 3/5/2006, passed in title suit number 73/2004, was affirmed. The instant appeal is admitted on the following substantial question of law. whether the learned courts below were justified in arriving at the conclusion that the defendant number one failed to prove that the plaintiff had refused the proposal. That too when both the courts below, and more particularly the First Appellate Court, had come to a finding that the defendant number one had advanced her proposal to sell her share to the plaintiff. Issue notice making it returnable by 6 weeks. Steps be taken by way of registered method.
Appellate.
What is this IA for?
IA for staying the appellate order.
What is there to stay?
Should I?
Your sale deed is, the sale deed has already gone.
But no effective order has yet been.
And there is nothing to stay.
Say, and melody in the meantime, I think from what have happened after 12 years, within 12, I do not have any track. Therefore, since the Lord is admit the matter, in case appellate order may be.
Absolutely no. Should we reject it or issue notice?
Beg your pardon.
Should we reject it or issue notice?
The Lord will issue notice.
IA, this is an application under Order 41, Rule 5 of the Code of Civil Procedure 1908 for stay of the judgment and decree dated 9/12/2012 passed by the learned civil court number 2, Kachar, Silchar in title appeal number 22 of 2006. This court, on a perusal of the instant application, is not satisfied as to whether satisfied on the basis of the requirement necessary in terms with Order 41, Rule 5. Not satisfied that the requirements necessary in terms with Order 41, Rule 5 have been met. Further to that, the instant appeal is being taken up after 12 years from the date of the judgment which have been challenged. As such, this court is not inclined to stay the said judgment without hearing the other side. Issue notice making it returnable by 6 months.
Appellate.
Steps be taken by way of registered declaration.
So far, the Contempt concerned, they have already appeared.
Who?
The last time someone appeared.
Take step.
Appellate. But name today in the positive, their name.
None appears on behalf of the petitioner on call. Taking into account the petitioner is not represented, the instant petition stands dismissed or non. Plaint. The interim order passed on 17/12/2015 stands vacated. The MK Cathedral after appearing of the appellate subject, he has instructed to withdraw the accordingly the extent closed on withdrawal in terms of the penny and ticket the LCR the pocket return.
But if this is I have got the service and a bit of file service.
Where is the order?
If it's not the page 44.
44.
Page 44, Annexure 9. Amendment of the plaint was allowed by the London.
Yes. What is the amendment for?
But there, earlier was for citation and cancellation of deed and confirmation of possession. We have stated the statement that in purchase here was the statement filed in the year 2030. Then 2040 filed an application saying empty recovery of transport prayer. That was rejected. Then they came to High Court. High Court that a proper to be filed and that to be considered in accordance of explaining all the facts. Thereafter, they have filed this application that page 36 is their application.
Yes.
How is that there is evidence. Have already stated but that before filing of the year for they
Now he has asked for recovery of khas possession.
without
Huh?
put the recovery of not
No, recovery that will happen after whether the order has been passed. Whether you will pay the court fee or not, that will be the court will put it later on.
there is no duty at the stage of witness they came the
Hmm?
at the stage of plaintiff witness.
Plaintiff has not given his evidence.
So,
till now.
he has submitted evidence in chief, but not like and only objection is that there is no duty at the end for already the first
We should record this submission
Yes.
properly
Got
so that later on when you come up with an application under order 6/17, we put that same thing.
sometime and come.
Then this is an application under Article 227 of the Constitution challenging the order dated 30/10/2016 passed in Mijay case number 27/16 arising out of title suit number 60/2013 passed by the Court of the Learned Munsif number 1, Gwalpara, whereby the prayer for amendment of the plaint was allowed. The case of the petitioner herein, who were the defendant, submitted that the said amendment which had been sought for was without due was sought for was at the time of when the trial had already begun, and the learned trial court, without looking into the question of due diligence, have allowed the said application seeking amendment. This court have duly taken note of the amendments which have been sought for in the application seeking amendment of the plaint. In addition to that, it is also relevant to take note of that the plaintiff has filed the suit seeking declaration of their right title and interest over the Schedule B land. Along with cancellation of the deed of sale and permanent injunction, restraining the defendants and their men from dispossessing the plaintiff from the Schedule B land. In the written statement so filed by the defendant, at paragraph number 10, it was categorically mentioned that the defendant number 2 has been owning and possessing and enjoying the Schedule A land of the plaint by making residential houses thereon. And it was completely denied that the plaintiff had, that the defendants had no right, title, interest, and possession over the Schedule B land. Thereupon, an application was filed seeking amendment of the plaint to insert the prayer for entitlement of recovery of khas possession by evicting the defendants. The said application was rejected by the learned trial court by an order dated 25/3/2015 on the ground that the court was not satisfied that there was due diligence. Inasmuch as the plaintiff had not mentioned anything as to why he was not able to raise the matter before the trial commenced. This order dated 6/5/25/3/2015 was put to challenge before this court in CRP number 252/2015. And this court, by an order dated 11/3/2016, by granting liberty to the plaintiff to file an appropriate application afresh, disclosing all material facts and furnishing necessary explanation as required by law under Order 6, Rule 17. It was further observed that if such application is filed with proper statement, the learned trial court shall consider the same in accordance with law. Pursuant thereto, the application was filed. Another application was filed by the plaintiff, which was under Order 6, Rule 17, which was registered and numbered as Mise case number 27/2016, wherein it has been mentioned that the plaintiff was in possession of the suit land before and also at the time when the suit was filed. But subsequently on 25/3/2014, the defendant forcefully and illegally dispossessed the plaintiff from the peaceful possession of the suit land. And it was on account of the subsequent events, there was a necessity of seeking amendment of the plaint. The defendants duly filed objections to the same. Pursuant thereto, the learned trial court passed the impugned order, which is the subject matter of challenge before this court. I've heard Mr. R. Chaudhary, the learned counsel, appearing on behalf of the petitioner. However, none has appeared on behalf of the respondent on call. This court, upon taking into account the facts stated in the plaint, in the applications seeking amendment of the plaint, the objections which was filed as well as the order which have been impugned, is of the opinion that there is no interference is required to the impugned order, taking into account that the amendment which was sought for in the application seeking amendment were trivial in nature except the prayer for recovery of possession. This court, further taking note of the proviso to section 34 of the Specific Relief Act 1963, is of the opinion that the said prayer, if not allowed to be inserted, would have consequences upon the plaintiff's case. Under such circumstances, this court finds no good grounds for interfering with the order dated 3/10/2016, for which the instant petition stands dismissed. The order dated 2012/2016 passed by this court stands vacated, and the parties are directed to appear before the learned trial court on 15/7/2024. Taking into account that the respondent herein, who are the plaintiffs, are not represented, the trial court shall issue notice informing them about that the suit is proceeding.
Yep.
Yes. What is this?
This application was filed on 27 for rejection of our application under order 927.
Order?
Order 927. Let's quote that. Lordship is page 28.
Order 9 Rule 7. Where is that order?
Page 28.
Petition purported to have been filed. Yes, what is wrong?
But there was detail of toothpaste, my lord.
Huh?
There was detail of
Have you filed your written statement in the meantime?
yes, but that day blood we file an application for getting blood, we also file a written statement. But
How do you know?
no blood that has been filed, my lord. I have just got.
Where is it mentioned?
Lordship also finds the at page 15, my lord.
What is it?
Page 22, your lordship would see para 4.
Understand these courts make it. This matter is pending for all this while.
Blood, yeah, indicated. Blood claim the money put is 4,50,000. In our written statement, we have indicated that 4,40,000 has already been paid to bank transfer and RTGS. Blood, the plaintiff here is in some pressure. Blood, after blood, the order was passed. Blood, it took test blood. Subsequently, we came to know blood that he has shifted to Agartala, Tripura.
Who?
Blood, the plaintiff. So, blood, we also file an application before your lordship for permitting us to take steps on her new act.
In this case?
Yes.
He has gone to Tripura?
Yes, he has. And your lordship, only thing blood, there was one default on our part that in between we could not take steps. But today, in fact, we have taken steps after coming to court.
Then what happened? Today you have taken steps. I'm beginning it. Why have you taken the steps only today?
But actually, there was a fault on our part.
This case cannot wait for all this steps.
That we taken.
When did you receive the summons? Where is the order of proceeding ex parte?
Page 13, your lordship would kindly.
Where is the order of proceeding ex parte? Hmm? Where is the order of proceeding ex parte?
That order.
And how do I know? When was it proceeding ex parte?
But it is, will kindly 16/6/2016.
Huh?
16/6/2016 at page 22, my lord. Para 4. My lord will see para 4.
No. Why you have not enclosed those? You dismiss it on that ground. These matters cannot go beyond this. Whether service is done or not, nothing done. These are such petty matters. Can't go like this and they just stay. Then who is going to pay the interest? You. Hard to pay.
But they also seem not interested, lord.
Who?
The plaintiff.
Plaintiff must have got the money.
But that is what we stated in our WS, that we have
Here's why.
already made the payment, my lord. If the lordship would see that.
Oh. This is an application filed under Article 227 of the Constitution challenging the order
Your
dated
lordship have a look at page 20, my
19/11/2016 passed in Manishut number 48/2015, whereby the application filed under Order 9 Rule 7 of the Code of Civil Procedure 1908 for proceeding ex parte for setting aside for recalling the order dated 16/6/2024. 16/6, no?
Yes.
16/6/2016 was rejected. This court have duly taken note of that the summons were issued upon the defendant on 18th of March 2016, thereby directing the defendant to appear on 12/4/2016. The defendant appeared on the said day and sought for time for filing the written statement. However, on 16/6/2016, as the defendant could not appear, the court passed an order, the learned trial court passed an order that the suit shall proceed ex parte against the defendant and thereby debarred the defendant from filing the written statement. It is under such circumstances, on 30/6/2016, the defendant, on coming to learn about the said order, filed an application for vacating the ex parte order dated 16/6/2016, and also on that very day, the written statement was filed. Taking into account the above, this court is of the opinion that the ends of justice would be met if the written statement so filed by the petitioner oblique the defendant is accepted in the records, taking into account that the said written statement was filed within the time permitted under Order 8, Rule 1. Accordingly, this petition stands allowed by setting aside the order dated 19/11/2016, as well as the setting aside the order dated 16/6/2016, as well as the order dated 19/11/2016. The learned trial court, that is the court of the civil judge, Kachar, is directed to accept the written statement and thereupon proceed with the disposal of the suit. This court further further to that, it is also seen that on 15/2/2017, this court had stayed the further proceedings from money suit number 48/2015. So this order stands vacated and the defendant is directed to appear before the learned trial court on 15/7/2024. Taking into account that the respondent is not represented, the trial court shall before proceeding with the further proceedings of the suit, issue due notice to the plaintiff. That is done, Remy.
Petition has been prepared by the insurance company, Your Lord. Including the order.
What are you challenging?
The claimant has filed an application before the tribunal seeking for substituting the legal heirs of the claimant. The claimant was an injured, Your Lord. But during the pendency of the claim, he died. So the legal heirs had filed an application for substitution. They have objected to it.
Right.
And thereafter the
Was it converted to a debt?
No, Lord.
Was it on account of that or something else?
It was after a long time, Your Lordship. So we have contended that the death was not due to the accident. However, at the relevant point of time of filing this application, the law was different. But recently, the Honorable Supreme Court have given a judgment, Your Lord. They have held that the legal heirs of the injured can also be. In the light of that judgment, Your Lordship, the matter can be.
Montfort?
Oriental Insurance, Your Lordship, and
Which order you are referring to?
Your Lordship, it is page number 27. Order dated 7/4.
Order dated 7/4/2017. It's an application under Article 227 of the Constitution challenging the order dated challenging the orders dated 24/5/2016 and 7/4/2017 passed by the member Motor Accidents Claims Tribunal number 1 at Guwahati in MAC case number 222256 of 2009. A perusal of the said orders revealed that the learned motor accidents claims tribunal had substituted the legal representatives of the claimant who expired during the pendency of the said claim proceedings. This court duly takes note of the recent judgment of the Supreme Court in the case of Oriental Insurance Company Limited versus Calhoun, Alliance Jasmal Singh Calhoun, deceased through his legal representative, reported in 2022 13 SCC 494, wherein the Supreme Court categorically observed that the legal representative can be substituted in a claim which is filed at where is that?
Paragraph 9.
In a claim wherein the claimant sought for compensation on account of injuries. Taking into account the above, this court finds no reason to interfere with the orders dated 24/5/2016 and 7/4/2017. Accordingly, the instant petition therefore stands dismissed. The interim order dated 15/5/2017 stands vacated, and taking into account both the parties are duly represented, they are directed to appear before the learned Motor Accidents Claims Tribunal, Kamrup Metro at Guwahati on before number what 1, 2, 3. It's number
1.
One.
MST 1.
On 15/7/2024.
Apply.
Hmm.
But if we have step on it, that it was on a step. A party take this step. Same method I am appearing as a legal cop.
Who?
I am appearing as a legal cop.
Why?
But the party I got
Where is the case file?
2022 31.
Where is the case file? Pending in the court of Matru to any and Lakhimpur. What about the service?
Service have to take place.
Yes, why you are not taking steps?
By day operation, we have taken steps, my. That has marked on,
Who is he?
2022 order,
Your, why,
2/12/2022.
he stays in Guwahati?
And the petitioner stay in Guwahati.
Huh?
Respondent stay in Guwahati.
So why you are not able to serve it?
I don't think he's staying at home.
Why does she have to come? You are legal aid, you help something, do something. You are the some secretary of the bar also. Then why you are not doing something for the people? You undertake to serve it. Yes. Mr. Isakya, appearing on behalf of the petitioner, submits that you take steps upon the respondent by way of dusty, rooted through the registry of this court, and file an affidavit of service on or before the next day. This court makes it clear that the petitioner herein need not take steps, need not affect the service. The service can be meted out through any other person known to the petitioner. However, that person needs to file an affidavit of, however, the person who files the, who affects the service has to file an affidavit. List the matter again on 5/7/2000, 22/7/2000.
There's an claim.
Huh? In term of the past earlier thing. Shall continue. Yes, where? Huh? Very well. Being a doctor, why you are filing all this?
They already settled that.
Huh?
They already settled that.
Good. The learned counsel appearing on behalf of the petitioner submits that he may be permitted to withdraw the instant petition. The petitioner may be permitted to withdraw the instant transfer. Accordingly, the instant transfer petition stands closed on withdrawal. The interim order dated 30/11/2022 stands vacated, and the parties are directed to appear before the parties shall appear before the learned district judge, Dorong, Mongoldor, on 22nd of July 2006.
May I please, I have entered appearance for response number 1, madam, in this case. My senior Mr. Bikosi is not well today, madam. I take up this matter on Monday or Wednesday, madam.
What is it?
My lord. Here, my lord, I have purchased the my lord, the scheduled property from the, my lord, son of the petitioner, the CRP petitioner, my lord.
You are the plaintiff?
I'm the plaintiff in this.
Take your seat, let him stay. Yes. Yes, what is your case?
Madam, we had agreed by an order rejecting our application under order 7. So my learned friend is the plaintiff, and I have the petitioner before lordship that the defendant number 2, 3, and 4 for the trial. Now the plaintiff case is that plaintiff had entered into had advanced some loan to the defendant number 1. My learned friend is, and in that agreement there was a clause that in default, if he fails to pay that loan, he will sell some property.
Huh?
He will sell one of his stock to the defendant number 1. Now that shop is situated in a government land. Now subsequently, an agreement for sale agreement has been entered in. Now plaintiff's case is that by virtue of that agreement for sale, he has acquired right. So now he has approached the court seeking his declaration of right over that government. Now he raised an objection that as this is a government land. Now, if your lordship kindly turns to page 35, madam. Page 33, madam. It starts from page 33, madam. Page 33, this is an agreement whereby the plaintiff had advanced loan to the defendant number 1. Now, page 35, clause 7. Page 35, clause 7.
Yes.
That the second party fails to repay the total amount to the first party within the stipulated period of 8 months,
then the second party shall be bound by law to deliver the possession of his aforesaid mortgage shop to the first party. Now, subsequently, this at page 36, my lord, notarized agreement.
Yeah.
This is deed of agreement for sale of possessory right. Now, this is an agreement for sale of possessory right. This is a notarized agreement. And page 38, clause 4, my lord. The plaintiff says that the page 38, clause 4. The vendor has
Delivered
delivered cars and vacant possession of the said shop to the purchaser. Purchaser has taken it, accepted possession of shop number so and so. Then clause 4, my lord. Next page, page 39. The page 39, clause 4. The vendor hereby agree to deliver the purchaser all deeds, evidences, and writing down in possession and custody relating to the title of the vendor in the shop hereby confirmed. And down the 7, that apart from that from the day onward, the purchaser is at liberty to file any application to take steps to get his name in the records of right of land patta before the concerned authority as per the provisions of Assam Land Revenue. And in para 6 also, my lord, para 6 above, that in
now
case,
what is the problem?
my problem is that, my lord, the prayer at page plaint, page 29, before going to the lot will kindly come to page 27, clause para 10. Now in para 10, the plaintiff says, para 10, the plaintiff begs to state that the land where the premises for the shop is situated is actually a government land. And in the prayer at page 29, the degree for declaration that the plaintiff is the lawful owner of due property on the strength of notarial instrument dated 2020. Now, we raise an objection. First of all, respect of a sale of immovable property, the plaintiff says that possession has been handed. If the possession has been handed over, as per section 17A, it has to be a registered act. This is not a registered act. And secondly, my lord, over a government land, the plaintiff is seeking a declaration of right title.
No, he's asking over the suit, property, the shop.
Shop, and shop land is on a government land.
So what? He's not asking for the land, he's asking for the shop.
While the shop is attached to the land.
So what?
So
The
he-
shop can be
So on the stand, declaration
shop,
that the
a
plaintiff
shop.
lawful owner of the
Schedule A is shop.
Schedule A, my lord, what
He's
is
not asking for the land.
Yes.
And also the right as to anything for patta and all these things. He's asking for permanent. No, Mr. Das, kindly see, he's asking for permanent injunction, not to enter into his disturb his possession. So,
if the suppose today
so
he
can a
actually-
suit be bifurcated? Tell me.
so that is why now if he
So
there
what is there? To
if it-
dismiss? Dismiss? Or what? Withdraw. Unless you say don't have this type of matters, absolutely encourage it.
because his alternative there is
What do you want? Option is 2.
Option A.
Okay.
Withdraw.
Later on, don't say while dictating that these observations may affect or Mr.
But
Ida.
only if I withdraw without not to be observed that whether this
I am not going to that. I am doing it by myself. I am only asking you 2 options. Option A or option B. Option A is dismissed, other is with. Option A, if I dismiss, it will be on my thing as to what are the observations required to be made. The moment I do it, then it is at your pretext.
option A.
Heard Mr. A. Das, the learned counsel appearing on behalf of the petitioner.
My lord, as has a recommend.
And
On behalf of people, my lord,
don't
number
come up
one.
with this B-story business.
My
You
lord,
are a lawyer?
response number one. Yes.
Are you a lawyer or not? Put your name.
As has a
And Mr. So appearing on behalf of the respondent. This is an application filed under Section 115 of the Code of Civil Procedure 1908, challenging the order dated 4/4/2023, passed in Midday case number 102/2023, whereby the application seeking rejection of the plaint was rejected by the learned trial court. But the question as to whether the issue which is involved in the instant proceeding is as to whether the learned trial court was justified in rejecting the application by the impugned order dated 4/4/2023. For the purpose of deciding the same, this court finds it relevant to take note of the brief facts leading to the filing of the instant application. The plaintiff, the respondent herein, as plaintiff had instituted a suit being title suit number 69 of 2018. The case of the respondent herein is that the respondent had entered into the plaintiff herein, where the plaintiff had entered into an agreement with Debraj Bhatta, who is the defendant number 2 in the suit, and also the proprietor of the defendant number 1. In terms with the agreement dated 24/10/2016, the defendant number 2 took a loan of rupees 8 lakhs on 15/9/2016 and agreed to repay the loan amount within 8 months from 15/9/2016, that is within 15/5/2017. In the same agreement, amongst various clauses, clause number 7 stipulates that if the second party fails, if the defendant number 2 failed to repay the total loan amount to the first party, to the plaintiff, within the stipulated period of 8 months, that is on or before 15/5/2017, then the second party, then the defendant number 2 shall be bound by law to deliver the possession of his aforesaid mortgage shop to the plaintiff. In clause number 8 of the said agreement, it was also categorically mentioned that both the parties agreed that in case of violation of any of the aforesaid terms and conditions by the plaintiff and the defendant numbers 1 and 2, by the defendant number 2, the plaintiff may initiate both civil and criminal proceedings before the appropriate court of law, and on that event, the plaintiff defendant number 2 shall be liable to bear the entire cost and consequences that may arise. From the perusal of the materials on record, it further reveals, from a perusal of the plaint, it revealed that the defendant number 2 did not repay the loan of 8 lakhs. And under such circumstances, a deed of agreement for sale of possessory right was executed by the defendant number 2 in favor of the plaintiff. Whereby the defendant number 2 transferred the possessory right of the shop, namely MS Bhatto Brothers, which have been more specifically described in the schedule to the plaint, at a total consideration of rupees 8,55,000 upon due receipt of the entire amount. It was also mentioned that the defendant number 2 had handed over the possession of the shop to the plaintiff. In addition to that, there were various other rights which were created on the basis of the said deed of sale, deed of agreement for sale of possessory right. It was further mentioned in the plaint it was alleged in the plaint that the defendant number 2 had thereupon collusively hatched the conspiracy with the defendant number 3, 4, and 5 by creating a tenancy between the defendant number 2 and 3. In order to frustrate the deed of agreement for sale of possessory right dated 24/5/2017. It was further mentioned that the defendant number 3 had also managed to obtain a trade license bearing registration number 54/19 dated 13/7/2017 from the Guwahati Municipal Corporation regarding her business, namely Sakshi Paper House. Further to that, after creation of all these documents as alleged in the plaint, a suit was being filed, being title suit number 227/2017 against the defendant number 2 as landlord by the defendant number 3. And the plaintiff was also impleaded as a defendant in the said suit. In view of the fraud being committed by the defendant jointly and collusively in order to deprive the plaintiff of his rights which had accrued on the basis of the deed of sale of possessory right, the suit was filed seeking various declarations, seeking declaration of the right, title, and interest, declaration that the plaintiff is the lawful owner of the suit shop which have been specifically described in Schedule A property, say in A land, and is the appropriate person to have possession of the suit property of the Schedule A for which consideration money have been duly received by the defendant number 2, declaring that the tenancy and the rent agreement by and between the defendant number 2 and 3 in respect of the Schedule A property as illegal, fraudulent, having no binding effect of the said tenancy upon the plaintiff, a decree for recovery of khas possession of the Schedule A premises in favor of the plaintiff by evicting the defendant numbers 1 to 5 from the suit premises, and by putting the plaintiff in actual possession of the Schedule A premises, a decree of permanent injunction restraining the defendants from entering into the Schedule A premises and from disturbing the plaintiff in peaceful possession of the Schedule A premises. And alternatively, it was prayed that the entire sale consideration of rupees 8,55,000 along with compensatory interest at the rate of 18% per annum thereto from 24/5/2017 till date of realization from defendant number 2 and actual recovery of the said amount in favor of the plaintiff by sale of all immovable and immovable properties of the defendant. Pursuant to the filing of the suit, which was registered and numbered as title suit number 69/2018, an application was filed under Order 7 Rule 11A and D for rejection of the plaint on the ground that the plaint did not disclose a cause of action against the defendant number 3, 4, and 5. On the ground that the the said defendants are not even remotely connected in respect to the suit premises of the case. In addition to that, it was stated that the plaint was also barred. The plaint ought to be rejected in terms with Order 7, Rule 11B, on the ground that the document on the basis of which the plaintiff claims his rights is an unregistered document and thereby being barred by the provisions of Section 17 of the Registration Act 1908 and Section 54 of the Transfer of Property Act 1882. It is relevant to mention that the said application was filed by the defendant numbers 3 to 5 and not by the defendant numbers 1 and 2. Written objection was filed to the said application by the plaintiff. The learned trial court, that is the court of the civil judge number 1, Kamrup Metro at Guwahati, by an order dated 4/4/2023, rejected the said application filed for rejection of the plaint. By holding that the suit that the a perusal of the plaint disclosed a cause of action, and further a perusal of the plaint, the suit did not appear to be barred by limitation. It is against that order, against the order dated 4/4/2023, that the instant petition has been filed under Section 115 of the Code. This court, I've heard the learned counsel appearing on behalf of the petitioner as well as for appearing on behalf of the respondents. Responded and have given due consideration to the relevant submissions. Before further deciding on the legality and validity of the impugn order, this court finds it relevant to take note of the provisions of Order 7, Rule 11 of the PPC of the Code. A perusal of the said provision shows that the claim can be rejected only in the circumstances stipulated in clauses A to F of Order 7, Rule 11. It is settled law that the clauses B, C, E, and F are not to be applied forthwith. Rather, an opportunity has to be given to the plaintiff to cure the said defect. However, as regards the clauses A and D, it is mandated that the same has to be given due effect. Now the question arises, what does the provision of clause A connotes? In the opinion of this court, the provision of clause A would only be applicable as to when a reading of the plaint, it does not disclose a cause of action. It is relevant to take note of that this should not be confused with the aspect of no cause of action, which only has to be decided at the final trial of the suit upon evidence being tendered. What is required is only to see as to, from a reading of the plaint, whether any cause of action is disclosed. Now coming to clause D, it stipulates that the said clause would only be applicable as when the suit appears from the statements made in the plaint to be barred by law. The same has to appear only from the statements made in the plaint and nothing further, as is well settled by various judicial pronouncements of the Supreme Court. In the perspective of the above, if this court takes note of the allegations made in the plaint, it will be seen that there has allegations made that the defendant number 1 and 2, defendant number 2, who is the proprietor of the defendant number 1, had initially entered into an agreement on 24/10/2016 with the plaintiff for obtaining a loan of an amount of rupees 8 lakhs with a promise to pay the said amount by 15/5/2017. It was also made clear, as per the said averments made in the plaint, that if the amount is not paid within the said period, that is 15/5/2017, then in such circumstances, the scheduled shop, that the possession of the scheduled shop shall be handed over to the plaintiff. It is further seen from a perusal of the plaint that the defendant number 1 and 2, the defendant number 2, not only did not pay the amount of rupees 8 lakh, but even took another an amount of rupees 55,000 and thereby sold the possessory right over the suit shop to the to the plaintiff by the deed of agreement for sale of possessory right. After doing all these things, after executing the said deed of agreement for sale of possessory right, the defendant number 2 created a tenancy in favor of the defendant number 3, his mother, and thereby have tried to frustrate the very deed of agreement for sale of possessory right. Under such circumstances, from a perusal of the plaint, it reveals that there is an element of fraud alleged against the defendant numbers 2, 3, 4, and 5 jointly and severally, and thereby hatching a conspiracy. Under such circumstances, in the opinion of this court, a cause of action, the plaint duly discloses a cause of action not only against the defendant numbers 1 and 2, but also against the defendant number 3, 4, and 5. Now coming to the question as regards Clause D of Order 7, Rule 11. The submission made by Mr. Adas of the learned counsel appearing on behalf of the petitioner is that the deed of agreement for sale of possessory right is not a document which is permitted in terms with Section 17 as well as 54. 17 and 17(1)(a) of the Registration Act 1908 and Section 54 of the Transfer of Property Act 1882. And as such, the suit is barred by, and as such, from a perusal of the statements made in the plaint, the suit is barred by law. The question as to whether the plaintiff would be entitled to the reliefs in the suit on the basis of the various provisions of law, more particularly Section 17, 17(a) of the Registration Act 1908 or Section 54 of the Transfer of Property Act 1882, has to be adjudicated by the trial court at the relevant time when such issue is being framed. Be that as it may, the suit also contains a prayer for recovery of recovery of money, alternative prayer for recovery of money. Of an amount of rupees 8,55,000 along with interest at the rate of 18%. Under such circumstances, the suit, from a perusal of the plaint, under such circumstances, on the perusal of the statements made in the plaint, it cannot be said that the suit is barred by law. taking into account above, the instant petition therefore stands dismissed. Taking into account above, it is the opinion. In addition to that, this court further makes it clear, further finds it relevant to observe that the suit cannot be partly rejected. The plaint cannot be partly rejected. And as such, the question of rejection of the plaint partly, insofar as the defendant number 3, 4, and 5, in respect to it is not permissible under law. Accordingly, the instant petition stands dismissed. And accordingly, this court is of the opinion that the learned first the trial court was justified in passing the order dated 4/4/2023. Consequently, the instant petition therefore stands dismissed with cost. There is a stay. Here is there. Cost of 25,000 imposed upon the petitioner, who shall deposit it the said amount before the learned trial court on the date so fixed by this court. This court, taking into account that the order dated 15/5/2023, this court vacates the order dated 15/5/2023 and directs the parties to appear before the learned trial court on 19/7/2024. 19/7 is too long, so nearby, we are nearby here. On 12/6/2024. On that date, the petitioners who are the defendants number 3, 4, and 5 shall deposit the cost of 25,000. What? Huh?
Cost amount may be considered,
25,000.
but it no cost be.
No. This is absolutely, you are in hand in glove with number 2 and doing all these things.
We are
Absolutely no, you are hand in glove and doing all these things. You want to delay the disposal of the suit. This is why you are doing all these things.
We have already filed a suit before the Munshi court not to dispose with the following due process of. Now, again, after filing.
You are filing a suit against your brother.
No, my lord, against all these persons. Because these plaintiff came and threatened us. We are in possession, my lord, of the short repression. The plaintiff came and threatened us that I have purchased it, we'll throw you up. Right? No, therefore, we have filed a suit.
You were therefore to say we have nothing to do.
No, that we have
in your written statement.
have
Unnecessary filing these things, you know it very well.
No,
Mr. Counsel, you knew it very well. This is an absolute abuse of the law. Therefore, I asked you whether you would like to withdraw or not.
but because
Now,
it
without
was a
withdrawal,
gov-
this
it
you
was
have
a
not done
government land, my
25,000.
lord. Our impression was it was as it was a government land, not government land and property situation.
So
now he's seeking, my lord, everything. Tomorrow he will go to this, what suppose the suit is decreed. With that he will go to the government, he will apply for, my lord, mutation and also. From that ground he has raised also.
what?
That this is not maintainable.
Suit may not be maintainable is a different question from suit being not barred by from a statement of the plaintiff. Isn't it?
Consider the cost amount.
27,500.
Deeply okay.
It will be 53 MI.
This is appeared by Mr. R. Sharma.
Yes,
I think who appeared on the last case. The matter came up before me. Asking him to file a list of assets.
Yes, my lord, it is filed, my lord, but there is some disagreement in my
You filed a reply.
lordship permit to it. If lordship permit, my lord, lordship may come to page 114, my lord. There are additional APDP. This is the salary slip. As per him, them that is grow and 39,997. Lordship may come to the next page.
114.
my lord. 115, my lord. This is the, my lord, their account statement, my lord. But my lord, this is a loan account, my lord. And my lord, interesting thing is that, my lord, the lordship may come to page 119, my lord. On 19/9/2023, my lord, they already paid the whole amount, my lord. Repay the loan, my lord. Accordingly, this account is closed, my lord. The petitioner ought to have filed their salary account statement also, my lord. It was not been filed. This is a salary alert government. 119, my lord. Last line, my lord. 19/9/2023. Discharge via transfer 7,67,147. Now, my next line, my lord, loan closed. My loan account is closed, my lord.
Loan account closed on in the month of September.
September.
Thereupon, how much is being deducted on account of loan?
He pay, my lord, 7,067, 7,67,147.
Here there is nothing of it. He has shown that loan account.
Yes, my lord. There's savings account. He might have a salary account, my lord. It was not been disclosed.
Page 91. No, page 91 does not show any loan account deduction. But how will he survive with 30,000 if it is taken away? How will he survive with 30,000 if it is taken away? He gets only 39,000.
Yes, he might have other source of income.
Who?
Petitioner.
I've asked the petitioner to file the list of assets. What did the petitioner do?
But he filed statement, but
how much the petitioner owes?
13 lakh. 13,90,000. 13,90,000.
How? On what? Oh, he had taken that money
My
for some agreement or something.
yes.
What is page 143? You have included.
Yes.
What is this?
Look, as per him, his daughter and he also took some money from some other person. He took some loan.
Mother.
His daughter, man. One for his daughter.
His daughter what?
Took some loan from other person.
None appears on behalf of the petitioner on call. However, Mr. A. Mubarak appears on behalf of the respondent. For the end of justice, the matter stands adjourned to be listed again on 27th of May 2024. It is made clear if the petitioner is not represented on the next day, the instant matter would be dismissed for default.
Appellate. 44.
Yes, Mr.
But I filed a amendment petition, my lord, for amending the written statement. That is at page 36.
What is the state?
But my stand is this, my lord, that adverse possession I want to claim of that.
What was your earliest stand?
But earlier stand was that the land on that land, some amount was taken. And unregistered document was given to me in that paper. But that person is not the person. Someone else might taken some money from, not person. And the plaintiff's case is this, that I have entered into the land court fully, illegal possession. And your lordship would be pleased to see the prayer in the plaint. Your lordship will turn to page 19. A decree for confirmation of right, title and possession. Decree to declare the defendant as illegal possession. And decree to evict the defendant from court from suit and work. These are the prayer.
Where is your original written statement?
Written statement, my lord, I have written. Your lordship will turn to page 31. Your lordship may please to look into para 11.
What is the amendment you are seeking?
But amendment, but in short, I want that I am in the land as adverse possessor. And consequently, but some paragraph.
not con. What you are trying to do is certain admissions which you have made on adverse possession. You want to take it.
But
You
your-
claim that you are a mortgagee of Honidor Deka, who is the son of, who is the father of the plaintiff, and on the basis of which you were,
but,
that is your case in your claim.
Punito Teka is not the Patata.
I'm not saying, you are saying. See in your,
Your lordship will turn to page
kindly come to page 33,
33.
paragraph 18.
Yes, my lord, that I am. That the defendant number 1 took possession of the said disputed property after being executed a mortgage deed by Punito Teka, father of the plaintiff on 13/12/96, and proudly cultivated by defendant number 2. This said land was cultivated by the defendant prior to execution of sale deed agreement. No objection was raised by any of the family member of anybody else. On 25.
Now you want to remove these admissions.
Right.
Okay. There's no quarrel. You can take a stand of adverse possession. The pleadings are already there to the effect of adverse possession. But what you are trying to do now, taking away the certain admissions. A mortgagee, you already claim that you entered into the possession legally,
My lord, only thing.
permissive,
One
and
point.
now you want to make it adverse. That is
My
not
lord,
permissible.
My lord, I want to place before your lordship only one point. Actually, I am in illegal possession. They want to say I am in forceful possession. So now I am claiming that it is adverse possession.
You
That is
have
the difference.
already claimed your adverse possession pleadings are already there.
My lord,
But what you are trying now by way of the amendment, removing those where you have duly accepted how you entered into the possession, your possession is now being shown the earlier, now you show that you have illegally entered into the possession and remained out there.
but that your lordship will consider this person, my lord, from whom I have taken mortgage, is not the Patata.
I don't know who it is,
My lord,
but you say that you took the possession on the basis of a mortgage executed by Ponidhar Deka, the father of the plaintiff.
father of the plaintiff, but Punito Teka is not the Patata.
That is a different thing. Whether he is a pattada or not, I'm not concerned. That is not your case out here. You are checking whether the plaintiff, are you claiming that the plaintiff is the owner now?
No.
If the plaintiff is not the owner, can you seek an adverse possession against the plaintiff?
My lord, plaintiff filed the case with the basis of a power of attorney. Is a power of attorney of the heirs of Patata. He is not the Patata. He wants to say, I am the attorney of the, your lordship will be pleased to see the plain. He is not the Patata. Lord, he is son of Punito Teka. Now your lordship will say, let Urikanto Teka was the original Patata of the shoot land. He is sole Patata and possessor of the state land. Said Urikanto Teka shifted to village Ramugri Hat so during his lifetime it started to live there. Said Urikanto Teka had given the shoot land to father of the plaintiff. He is not the original Patata. Named Punito Teka as Ati Basic.
Paragraph 4.
Yes, madam. Basic. The father of the plaintiff, late Punito Teka, had been possessing the shoot land by plowing. Now, your lordship, after the death of Punito Teka on 29, 8 son and daughter of the Gaurikanto Teka, Sri Deepak Teka, Raju.
Now you duly admit that you have taken it from Ponidhar Deka.
Yes.
So why you are removing that admission? Not permissible.
Actually, Punito Teka is not the Patata. That I will.
Whatever may be, but you have, whether it is there or not, these amendments cannot be permitted. This is not an alternative plea. This is the case where you are withdrawing admissions. Withdrawing admissions is
My
not
lord,
permitted.
in that case, my lord, your lordship consider some decisions I am to place it.
Yes.
Your lordship 2017 8 SCC.
Hmm.
Para 8.
Yes.
2017 8 SCC, my lord. 6-7 para page 1 to 3 of my compilation, my lord. Para 8 I want to refer. Para 8. Amendment seeking only to elaborate and amplify the defense. Allowed.
Okay.
Then, my lord, the 2009 14 SCC, page 30, 38, my lord, in my compilation 9 to 14. Right, here it is said that issue yet been framed, but in my case, issue already framed. The document have not yet been filed. Evidence has not yet been adduced.
No,
Evidence is
we are not on that.
My lord,
Mr. Take, I'm not on the question of delay. I'm on the question of changing, taking away admission.
so my lord,
This
I
is a
can
case of taking away.
your lordship already pointed out that I can take the alternative defense.
Alternative you can. There's no quarrel, but you can't take away the admissions. You can't take away. Here, there are admissions. You are completely removing them. You see, if you allow this will have a far-reaching consequences. Every time you want, you change your entire pleadings by filing it, okay, whatever, because admissions can't be taken.
Your lordship, may I submit one thing? Before amendment of the CPC, here was a provision that nature and character of the suit should not be sent.
That
Now, my lord,
remains still.
after amendment, that clause is not.
No, it is still there. There's no quarrel with that. These are all there. But the only thing is, we are not on that. We are on the very fundamentals of there, saying you cannot change, take away admissions. You have removed paragraph 18, which is very dangerous, what you have done. I therefore saw what amendments you are seeking to paragraph 11 and 18 of the written statement filed. Both the paragraphs you have been taking away, where you have categorically admitted.
My humble submission before your lordship is this. After amendment, that clause is not there, that we
It
cannot.
is not the question of changing the nature and character.
Well-
It is a question of you are changing, taking away
Six-
admissions.
changing my
These are
and-
admissions in terms with the Evidence Act. You are a party who have you power to do so, and you have done so. Taken away these admissions. You can't take away these admissions. Oh, it's very clear.
In that case, my lord, may I submit before your lordship
Yes.
regarding this alternative defense, my lord? Some of the
Alternative, now you already have the defense of adverse possession. If you see paragraph 11, paragraph 18, these are all allegations of AI. Yes, you can very well could have given that, yes, from such and such date we have done that. Give more amplifications that this is what is there. We have not earlier stated from when we were required to, we had entered into possession, how we have entered into possession, what are the possession, what is the adverse when these people came over, we have asked them to leave. All these things are questions of facts which you could very well insert. No quarrel with that. Here you are asking for adverse possession. There cannot be an alternative plea to an adverse possession. Kindly appreciate that. You already have asked for adverse possession. Now what you are saying, you are removing those admissions where you are claiming that this, I had taken this land on the basis of legally entering. Once you legally enter, where is the question of adverse possession? It becomes a permissive occupy.
Now your lordship, where I am stuck now, as your lordship pointed out, that your admission cannot be taken. Now, my lord, as I have already filed an amendment petition, supposing what your lordship revealed that that much I can take. So, my lord, once I have filed the amendment petition, second amendment petition possibly would not be possible on my part. That will be a part.
Can't help you. What do I do? They did not approach Mr. M.A. at that point.
We are in continuous possession for 20 years.
From 96. No quarrel. You say that. But you can very well ask for amplification in view of that judgment 2017-8. Ask for amplification.
But actually what happened, your lordship rightly pointed out, they did not come to our hearing. A plea has been taken, which not at all proof. Because money was paid to some person, who is not part.
I am agreement. There are various provisions. Amendments, other amendments are okay. But amendment to 11 and 18 is not possible. And without amendment to 11 and 18 properly done, you have no case. The others you can. Others are okay. I'm not touching on that. That he doesn't have the right, he could not have filed the suit and all this.
Submission before your lordship.
Huh?
If para 18 remains,
Yeah,
it will be difficult, very difficult for advert protection. Ultimately,
so that is why I'm saying it is a case of admission. And with that admission, tomorrow you will be in debt. You cannot take away that. What to do?
but may I pray before your lordship? As your lordship, from the fact it is seen that actually we are advert possessor over the land. So regarding this, that portion, that amendment of that portion cannot be allowed, other portion can be allowed. That observation, my lord.
Like paragraph 2, you cannot. See page 39, what you are saying. Defendants all knew that the suit patta is the patta land of Puri Kanta Teka. Now you want that who is the true owner. As the suit land was found lying vacant by the defendants, so they came into possession of the suit land. On the other hand, earlier you say that you enter on the basis of mortgage. It's not here. It's taking away admission.
No, Lord, my alternative prayer before your lordship, not interfering with the order of the court below, my lord. Only thing that his admission cannot be taken away by the petitioner before your lordship. But other amendment, my lord, that can be allowed.
Huh?
Other portion, my lord. Admission portion may remain as it is. That cannot be amended. That observation is possible, my lordship.
See, Mr. Sheikh, you can amend, bring in 4, 5, 9, 13, 11, and 13. Other amendments cannot be permitted. This would not take away those admissions. Where 4 says, who is the original patadar? You also admit to that.
Yes.
Who is the original
Yes.
patadar?
Yes.
He also says that the power of attorney which was given, that is a question he can very well raise.
Yes.
Even that, without taking that also, he can raise it. Power of attorney, because it is you who are to prove that. Because you say. Then 5, the plaintiff, the defendant cannot file, the defendant state that the plaintiff cannot file the suit on the basis of the power of attorney. So this is the same. Paragraph 5, page 43. Then 7 is not permissible. 8. That the statement made in paragraph number 4, it's stoutly denied by the defendant that Honeyder was not in possession of the suit land in any point of time and he never cultivated the state land as adhyar.
That is a admission earlier.
Earlier, what do they say? Kindly see paragraph page 32. The paragraph number 4 of the plaint is specifically denied by the defendant. It is true, not true that the plaintiff's father Ipanaya used to cultivate the dispute till his death as adhyar. Actually, as instructed, they have wrongly put it should be Ponidor. So this is already there. Plaintiff's father is already there. So this is there. So there is nothing, there is no change to that. This is already there. This is exactly never cultivated the land as adhyar. Only word is as instructed by Gorikanta Kolita, that is not there, but that is not material. Then 9. Of the year, the defendant states that the plaintiff is to prove the power of attorney as a bona fide legal instrument for the suit land. The defendant states that the power of attorney is not legal and not enforceable. It can put 9.
Yes.
11, that the statements made in paragraph 8 that the plaintiff defendant states that the same is totally false and concocted. The plaintiff never cultivated the state land by tractor on 2022 of Ahar month for raising Kali, and on 25-26 of the state month the plaintiff did not visit the suit land. The defendant never said that the plaintiff that there was a sale agreement between the defendant number 1 and the father of the plaintiff in respect of the suit land. There was no exchange of words between the parties. Now, let us see paragraph number 11. Yes. Dispute inherited by so-and-so alias Ponidor, but Goriganta to name mutated his name with a view to keep the plaintiff. Suppose the state plot of land was first possessed by way of mortgage, executed by Ponidor on demand, and was under mortgage up to so-and-so prior to the execution of it. So these 11 not permissible. Then 13, that with regard to the statements made in para 10 of the plaint, the statement defendants state that they are in continuous possession of the suit land as the first possessors over the suit land for the continuous 22 years as of so and so. When the suit was filed and till date, they are continuing in possession. That is okay.
That is already there in para 10 of the.
Yeah, so let it be there. Now, 18 not permissible. Schedule of the written statement may be deleted. What is the written statement schedule? Plot of land measuring 2 bighas, so and so under it. Why they are mentioned about the schedule? So, deletion of the written statement schedule, no problem.
Yes.
Others are okay.
But if schedule is not there, it is.
It is his problem, isn't it? Okay. We are not allowing I, G, I, E, I. Mr. Sheikh, you are okay with this?
My lord, just want that schedule, regarding schedule.
You want the schedule?
Why that it has been taken? Let me want it.
There's no mention out there in the schedule. I don't understand. Why did you put the schedule at all?
Actually, this schedule,
In fact, you have already.
Elite with schedule is 21 schedule. Madam.
Huh?
Same schedule.
What?
Page 21.
No,
schedule of
no,
the
no, no,
plaint.
no, no. You have put a schedule in
Madam.
your written statement. Why? There is no reference to the in your statement.
Well, it is not necessary.
That is why. It's okay. We are not.
Schedule in the written statement has been given. Well, in the plaint, what schedule is there? Same schedule has been put in the written statement of original. That will remain.
Is an application under Article 227 of the Constitution challenging the order dated 21/9/2023. Past in petition number 258/21 in title suit number 79/2018 by the court of the learned court of the Munship number 2 Nalbari, whereby the application seeking amendment of the plaint was rejected. This court had duly perused the written statement which was filed by the defendants. No? How many defendants?
Defendants.
One or two? There are two by the defendants. On 30th of March 2019 in the suit. This court further have also perused the application seeking amendment of the written statement. A perusal of the said application reveals that at paragraph number 4, the defendants have categorically stated what are the amendments which have been sought for. This court have heard Mr. M.A. Sheikh, the learned counsel, appearing on behalf of the petitioner, who submits that the learned trial court ought not to have rejected the said application, taking into account that the said amendments which have been sought for amounts to amplification of the defense already taken. And as such, there is nothing new which has been brought in. On the other hand, Mr. B. Bora, D or B?
BP.
BP Bora, appearing on behalf of the respondent, submits that there are certain amendments which have been sought for, by which admissions made in the written statements have been sought to be withdrawn, which is not permissible as per law. This court, upon perusal of the said amendment application, finds that at paragraph number 4, the various amendments have been sought for, have been serialized, enumerated as serial numbers A to J. From a perusal of on a conjoint reading of the application, written statement, along with the amendment application, it is seen that the amendment sought for at serial number A D G, I are amendments by which the defendant seeks to take away the admissions which have been categorically made in the written statement. This is not a case where there is a setting up of a new case by change. This is not a case where the amendments would change the nature and character of the defense. But here is a case where the defense so made is said to be, the admissions made in the written statement is sought to be withdrawn, more particularly at the paragraphs above mentioned. Under such circumstances, in the opinion of this court, the amendments which have been sought for in paragraph A, paragraph 4A, four D, four G, four I cannot be permitted. Now coming to the other amendments which have been sought for.
For E also.
For E.
For E.
That is, he has already stated the same thing. This is the paragraph number 4. Paragraph number 4, he duly mentions there's a mistake about Ganesh Chandra here, but it is otherwise same. There is nothing much. However, as regards the other amendment, at paragraph number 4B, 4C, 4E, 4F, 4H, and 4J, in the opinion of this court, would not change the nature and character of the defense, would neither change the nature of the character of the defense, nor amounts to withdrawing of any admissions. Rather, these amendments are amounts to amplification of the statements which have been already made in the written statement. In respect to the amendment which have been sought for in 4J, which is amounts to deletion of the schedule to the written statement, in the opinion of the court, the same is essential, taking into account that there is no reference to the schedule in the written statement. Taking into account the above, this court therefore disposes of the instant writ petition by partly allowing the amendment application to the extent of only paragraph number 4B, 4C, 4E, 4F, 4H, and 4J. However, the amendment sought for to insert or substitute paragraph by paragraph number 4A, 4D, 4G, 4I, cannot be permitted. And as such, the amendment application in so far as those paragraphs stands rejected. This court, there's no stay.
Stay was there, man.
Huh?
Stay was there. Order dated 11,
Oh, there's a
6,
stay.
11, 2023.
This court vacates the order dated 6/11/2023, whereby title suit number 79/2018 was stayed, and directs both the parties to appear before the learned trial court on 14th of June, 14 is too long, on 3rd of June 2000,
My lord, may I pay on any Saturday?
Saturday.
Saturday.
You are going?
Yes.
Okay. 15th of June 2024. On that day, the amended written statement shall be filed by the defendants, else the provisions of Order 6, Rule 18 shall come into play.
Oblige. DPO. Pastor.
Mr. Bora, just have a look, if I'm not wrong, huh? Once again, you have a look. Yes, madam.
It is not the plaintiff lordship seeking amendment. Their amendment was rejected. Case of the plaintiff is that lordship their father's land was an ancient particular land. Page 55, same short.
Where is the amendment application?
Page 50 here.
8.
50. Annexure 5.
So you wanted to insert this. What was the state?
State lordship witnesses were examined part.
So now you sought for a relief for declaration that this deed in favor of AI is illegal and liable to cancel.
But
Why
already
so late?
Already that reading was in the plain paper. After the written statement, we have already amended our plea. The pleading was already incorporated in the amended plea. Only the number of the deed of respondent defendant number 8 was not mentioned, and no prayer was sought for cancellation.
Where? Where is that application?
No, that application is not there. Your lordship will find it the amended page. That portion is in this amended plain. Page 18. Last paragraph 11A.
8.
18. 1.
But it is not the number. Now you are saying about registered. Earlier it was unregistered.
No, Lordship, there is a unregistered deed executed by the predecessor of the plaintiff in favor of defendant number 2 court. It is their contention. That is
No. What you want? You want 11A after subpara after 11A is to be added.
Lord, 11A was already amended, and after that para, Lordship, we want to incorporate this specific there.
Why?
Showing the sale deed in respect to defendant number 8.
Why have you not mentioned earlier? Where is it mentioned for defendant number 8 sale deed? You say that it is being mentioned, the number is not mentioned. Where?
Lordship, the pleadings is there that to defendant number 2 to 4 cannot sell the property in favor of defendant number 5 to 13. That specifically pleading
5
was
to 13.
Yes.
Okay, then.
so
No,
eight-
that is not there. This it is not the correction. You are inserting now that registered having no number so and so executed in favor of the defendant number 8 is illegal and liable to be cancelled. By this deed of sale, the defendant number 8 could not acquire any right, title, and interest over the, what is that?
Page 19, your lordship
Now
will
kindly
find
come to page 50. Over, what is this?
oversight, lordship.
Huh? Over
Five-
the
50.
page 50. Last line. Over the
By this deed of sale, the defendant number 8 could not acquire any right, title, interest over the scheduled land mentioned in the sale.
what is this question? This N. Again, you are going to come for another thing.
Over the scheduled land, it is that and was
Then where is your relief sought for?
relief page 51, lordship.
D1. D1 is not there.
51, lordship, 14 D1.
This is another deed. You are asking for 1803. DD. D1 I you want to put.
Lord, it
So this
14,
is not an oversight. This is you have not inserted this.
Lord.
Then
that was not
now who is
inserted.
going to file the he has to file a written statement. Who is appearing?
Private department.
Oh, cost 25,000. He has to file. I hope you are charging that. He is charging.
My lord, one thing I want to point out,
Yes.
in the plaint 2015,
Uh.
the original plaint, where the amendment they have asked for now, that has already been amended for that same reason before.
Hmm.
And that is the finding in the this impugned order.
Hmm.
That I am reading out.
Yes, read it out.
Yes, my lord.
Page.
Now the finding is that
Page.
it starts at the order starts at page 55.
Which portion you are
Yes,
referring?
I'm. I'm at the middle of page 56, the second paragraph.
Okay.
It is not a rare-centric that matters relating to amendment of pleadings has to be looked into and considered liberally. The same being matters of procedural law. However, it is equally well settled that state principles shall apply only when the plaintiff is able to satisfy the court. There is no laches or willful negligence or want of due diligence on this part. It has been seen that the present suit is pending since more than 7 years. And the plaintiff has already amended the plaint once, after which the trial got commenced and reached the stage of cross-examination of plaintiff witnesses. It is at this stage of proceeding that the plaintiff has now come up with a present petition for amendment showing frivolous and princely ground oversight. Hence, considering the conduct of the plaintiff, the plaintiff appear to be from record and also want of due negligence, the petition is rejected. Now, my lord, this same some numbers of sale deeds has already been amended in the amended petition that has been annexed here. And before that, there was another petition, title suit, where they said that it was wrong, the number of the sale deeds. So they have been allowed once to correct the number of 2, 3, more than one from this order, what I can see. And after that, they are again trying to change some other sale deeds number. So what remains of the original suit, my lord? Everything they want to change. So when the suit number changes, when the sale deed number changes, that means they are trying to bring in another suit.
And why at the time of cross-examination?
Lordship, the defendant's case is that lordship defendant number 224, lordship, defendant number 224 parte to an unregistered deed, the annual factor from the.
No, you knew about this deed.
No, lordship, they have not mentioned in their written statement.
Then why have you not mentioned that you have come to know only at the time of cross-examination?
That was not mentioned. Lordship.
Then how do you explain the delay that of filing this at such a belated stage?
But some of the deeds already incorporated in the amendment.
Some of the deeds may not. Why you have not done it? Because now what will happen? The suit again goes back to that stage.
That deed by which the defendant number 8 became owner lordship. That was challenged through this application. Earlier, there are some deeds in respect to defendant number 5, defendant
I've
number
seen it.
30.
DD.
Lord.
DD prayer is 1803.
Yes, lordship.
Understood, but this is not the 1803. What you
1433,
want to do, you want now to put in another paragraph, another, yeah. Now the defendant number, who is appearing for defendant number 8? So yes, now again to file another written statement. Now the suit goes back again. Now there will be, have to be again another issue frame. Again, you will start giving evidence.
I am thinking and lordship, the suit is only at the stage of cross
Because now you have to give again fresh evidence.
in respect to defendant number 8.
No, you have to give any additional evidence, you will have to give it. So all the entire thing, when was this amendment filed? Mr. C. Sharma, you tomorrow
2023,
calculate. I'm having this matter later on. You calculate how many dates have gone thereafter. Each date, how much the client had to pay to the lawyer. Give me a detail of the cost. We'll impose it upon them. Exactly.
17/3/2023.
I put it in the order. You put it on there by way of an app. I put that, impose that, because this cannot like this happen, because this is absolutely a gross negligence. You put it by way of an affidavit as to how much would be you have paid after, because once amendment has happened, there was negligence. Okay, now the suit has proceeded there. Again, coming back to this position, to the pleading, issues, written, then evidence again filed. Then again you cross-examine. Partly you must have done it. Okay. List the matter. How much time you require?
2 weeks.
Not activity. Only give the details. List the matter again on 29th of May, on which date Mr. C. Sharma shall file a short affidavit giving details as to the expenditure so incurred by the defendant since the date of filing of the additional written statement to the amended statement in the title suit number 198/2021. The same is done in order to recompense. The same is done to estimate in the same is done so that if this court allows the amendment to calculate as to how much amount is to be awarded as cost to the respondent to recompense to the costs so incurred by them. Right. Interim it will get. Yeah. Yes.
Your Lordship, an arbitral award has been stayed. Complete stay has been granted without even issuing a notice, without impugn order is at page 83.
Huh?
The only ground is that as the case has already been admitted for hearing, the suspension of the order of judgment that is a spontaneous flow. Your Lordship, judgment in city construction, I would be relaxed for.
Money,
Money.
how much?
Total amount comes to 1,91
Oh.
lakh.
Or who are you? Correct?
ONGC.
ONGC. Hidden amount. What is this? ONGC has to pay them. You interfere with this on immediately.
Notice was otherwise issued.
What?
They've stated that their prior notice under 34(5) was not issued to them. That is perhaps not the case, my lord.
I'm not concerned with that.
And that is one of
34.5
the
we are not. We are not on 35.5. We are only on the question, where is the question of stay like this? The question of stay does not arise like this. ONGC, you are big man. You pay 60% and 40% in bank guarantee.
Let me indicate the time period of
Very well. 1 week,
very difficult within
2 weeks.
at least 4 weeks.
No. You have already enjoyed from 13-12.
No, the stay has been lifted, but they're proceeding with the execution.
Stay has been vacated.
Yes, in these
No,
very
because
proceedings.
this order was stayed initially when we moved it here.
It has been stayed.
Yes.
This
Oh,
order
then-
stayed, thereafter we file an execution. Nothing is proceeding. They have taken the plea because this issue is pending before the High Court. Since this
Okay,
order,
we dismiss this decision matter. There's already state. This order is absolutely incorrect.
State by this honorable court.
Huh?
State by this honorable court in the CRT.
State?
The order of the arbitral award, that was stayed by the learned court. The impugn order, I may say so, has been stayed by this honorable court. In
Understood. Therefore, he is going for execution.
Yes.
So under such circumstances, let him continue to go ahead unless you give an undertaking that you are going to pay 50%, 60% and 40% bank guarantee. Very well.
May I just crave for it to be listed on Monday? I'll get it in writing.
Fantastic. Take this order.
On Tuesday.
You see, these orders have passed it only on the basis of the Supreme Court judgment. Now, this is the law. All these days. Wherein it says 60% depositing, remaining 40% is secured bank. This is the law. In some cases, the Supreme Court says here, in this case, 100% deposit. When this is too rich, hello, release the matter again on Monday.
On Tuesday, Mother?
At 2 p.m.
On Tuesday.
Monday, release the matter of the petty matter. On Monday, Mr. P. Talukdar appearing on appearing on behalf of the respondent, ONGC, submits that he may be given an opportunity to obtain instructions as to whether the respondent would be ready to pay the 60% of the decretal amount and the remaining 40% as by way of bank guarantee. This the matter again on Monday. Monday, now we'll have it on Wednesday, 24th.
23rd.
24. 24th is what? 24th is?
Friday.
Today is what?
Today is the 17th.
17, no. So then Monday, 22nd. Oh, no. Don't go here, Sulobo. I am today 17. 22nd. It will be on Wednesday. Yes, madam.
State proceeding execution have filed order 2197 project. That was accepted and next date was fixed for shortly objection of the other side, but no stay was granted. Then later on we have filed another application under section 151. That case also no stay was granted.
I gave you a stay. Now what, it has stopped. Now your execution is going on. No, your order 21 rule 97 is going on.
Yes.
Then what do you mean? Where's the other side? That an affidavit in respect of dusty has been duly filed. This court fixes the matter and so on.
I have filed affidavit.
You filed the affidavit.
Yes, but they refused to accept.
Does the court know about this thing? The trial court?
I have submitted the
The trial court has stayed it now.
Yes.
The execution.
Yes.
But the order 21 rule 97 is going. How much time would it take? What is the stage of order 21 rule 27? Let us have this thing in the month of September, 2nd of September. On 2nd of September, let us see, we'll get a progress of what is happening in order 21. Heard Ms. R. Chaudhary, the learned counsel, appearing on behalf of the petitioner. None has appeared on behalf of the respondent. even after due service of notice upon the respondent. So this court have her state. Ms. Chaudhary, the learned counsel appearing on behalf of the petitioner, submits that pursuant to the order passed by this court on 18/3/2024, the further proceeding in the further execution proceeding in title execution case number 1/2023 has been stayed by the learned executing court. However, the proceedings under Order 21, Rule 97 and 101, which have been registered as Ms. J case number 6/2024, is presently going on. So, taking into account the above, this court further extends the interim order passed on 18/3/2024 till the next date. Lists the matter on 2nd of September 2024. In the meantime, the executing court, that is the Court of the Civil Judge Junior Division Bijni, is directed to give a status report as regards the status of Ms. J case number 6/2024 on the next date. So, the registry shall duly intimate the learned court below about the instant order. Yes, any urgency? Any urgency? Yes, Mr. Arbot. You have been sitting out there idly. Yes.
I have but we are fixed for order to our local target. It may come on any other day.
Which one? How? What has happened with this how? Why is it?
Ultimately, route the office noted 4/5/20.
Yes, what has happened? Give me the how. This how, wherever I see this house, this needs to be finished. But immediately. Yes, others may go. Let me finish up this talk. Yes, what has happened? Let us see what is the order pass. It's a remand. Yes, so remand.
It's a remand.
Remand form.
Remand minus by the first separate court. That order lordship will find. My lord, it starts from page 32 of the memo.
Why is this required?
It was filed by one of the co-owners, alleging that the person who had executed a sale deed in favor of the defendant number 4, because I am the defendant number 4. So I purchased a part and parcel of plot of property along with a building out there in Nagaon. Now, the person whom I have purchased with due process of law, I have taken all the measures. And thereafter, this suit came to be filed by one of the family members, alleging that that sale was done fraudulently. And in the suit, if may be pleased to come to page 11. Page 11, that is the prayer portion of the plaint.
Yes.
So these are the prayers. Decree for declaration passed that in the register sale deed number so and so is false, manufactured, and fraudulent work. Decree declaring that the plaintiff has right title and interest over 1/4 share of Schedule A land, then precept, permanent injunction, and these are the prayers.
Yeah. The suit was dismissed.
Suit was dismissed.
Now, show me.
My lord, against.
Why the trial first appellate court remanded? I didn't get it.
Yes, yes, first appellate court remanded.
Kindly come to page number 41.
Yes, page number 41.
Last portion. In the instance suit, it is seen that the plaintiff nowhere accepted that the signature exhibited in Exhibit 2 as signature put by him.
Hence, on the basis of oral evidence adduced by the plaintiff as well as the defendant's side, it cannot be conclusively held that the disputed signature filed Exhibit 1 is of the signature of the plaintiff. As the answering defendants desire the court to believe that the signature filed Exhibit 1 is of the signature of the plaintiff. Hence, it is the duty of the defendant to prove the fact that the signature exhibited by Exhibit 1 is of the signature of the plaintiff. Hence, it is the defendants who have to prove in the suit that the signature exhibited so and so, the cell deed bearing so and so, is of the signature of the plaintiff only. And in the instance suit, the defendant had failed to prove such fact by adducing sufficient convincing evidence as required by law. Hence, my considered opinion is that the learned trial court committed wrong in holding that the plaintiff failed to establish the fact that the registered cell deed is a manufactured false and fraudulent one, but they are the answering defendants who have to prove the fact that the signatures exhibited, the filed Exhibit 2 in the cell deed bearing so and so is the signature of the plaintiff only. And to determine such question, the learned trial court ought to have obtained.
So why the first appellate court could not have exercised the power of appointing the directing for examination if it was necessary? It was not necessary.
That can also be done.
Yes. Why is it the case of remand? The first appellate court could have very well decided this and directed, okay, directed the examination of the signature if necessary. It's not necessary for this all this thing.
That observation may be reflected. That observation may be reflected. That the first appellate court can.
We set aside this order and direct them to decide, and if necessary, if they feel they can very well, in exercise of the powers under Order 41 Rule 27, the court can do so. B. 27B. The court can do so. If they want, they can ask for examination. If they want, anybody wants to the.
But the fact remains that it was a registered statement. It was a registered. So therefore, my lord, the LCS were called for. LCS are not reported on my book.
We don't require LCS for this type of matter.
Because it was, my lord, registered statement. It is present, my lord. Legal presumption is there that it is a registered statement.
Legal presumption, everything that is for the first appellate court. Either you see the scope out here in a SAO is very limited as to whether it is a case should have been remanded or not. The trial court would, the first appellate court could have done under Order 41. They can do it. But what the only thing is to see is as to whether the remand was in conformity with Order 21 Rule 24. Now, if it can be on the basis of the evidence, he can do it. Let him do it. He can very well, if he wants a signature of him, if he wants to be satisfied. Otherwise, the defendant case is bad. Or it is the case of the plaintiff would be bad. He has to decide. But where is the question of when defendant is not asking for evidence to be produced, the plaintiff is not asking, why are you asking, sending it to the handwriting expert?
Even I can file an application on the order for.
Understood. You can file, you are a plaintiff.
Yes.
He can file if he wants. But the fact is, it is not for the court to go and find out. No, if somebody is saying that this is my signature, this is not my signature, it is saying, if the court wants, the court can very well ask them. Has the power that we direct it for appointment of a handwriting expert. First, this court also have to realize that the evidence under 47 is a very weak evidence. One has to look into on the basis as to that proof of that this is not his signature is either by that person concerned or by a person who knows his signature or a person who is acquainted very much with his signature to that effect or who have done all this thing or by a handwriting. The handwriting comes at the last.
Therefore, because all other witnesses were examined. All other witnesses were examined, and thereafter, my lord, the trial court came to definite finding. Now, only because of the fact that the person, my lord, disclaims that it is not my signature. Only because of the fact that
he merely, first of all, if he wants to say that it is not my signature, He can very well say that this is not my signature. But how will he prove?
The ownership. The ownership.
Onus is you. You are to say that it is fraud.
Yes, so therefore they had not taken any step at the trial stage to call for a handwriting expert. Now evidence, everything has been, my lord. My lord.
Appellate court.
All the evidence, my lord, are complete. They have not chosen to call for handwriting expert. It is only for the first time that in the first appellate court, my lord, the first appellate court has so moto, my lord, taken cognizance of the fact that no, now whether that is permissible.
Absolutely no. What the first appellate court has done is this paragraph 9 and 10 is wrong. We interfere with this thing and direct them the first appellate court to decide on the basis of here. If the first appellate court finds that it is necessary, it can do so in terms with Order 41, Rule 27. Otherwise, the parties are given the liberty to file appropriate application if they feel so. Because it is whoever's burden, his burden it is.
His burden, but at the appellate stage, my lord, can he now file an application, my lord? Will he not be exposed? Because at the trial stage, he had every opportunity to call for, my lord, expert evidence. He has chosen not to call for expert evidence. It is he who has denied. Now, at the appellate stage, I lose, my lord. I have taken a defense, my lord. I am the defendant. I will take all possible defense.
No, you see, you have to understand one thing. This is a question of appreciation of the evidence, how the court is going to do it. Now, he is the best person to say this is his signature or not. But the fact as to whether he has signed it or not, he cannot say. Do you know why? That day I saw a very beautiful illustration. A very nice illustration in the evidence.
I have opened all my cards, everything. Oh, my lord. At this stage, my lord.
No, it's okay, but I'm not on that.
My lord, I will be prejudiced.
No, there's no question of prejudice or anything. There's no opening your cards. Your cards are already open.
In fact, appellate court also discussed section 70.
This is exactly your case. It is an application under, is an appeal under order 43, Rule 1, T or U?
You.
Of the Code of Civil Procedure challenging the order dated 12/8/2016, passed in title appeal number 04/2013, whereby the Court of the Learned District Judge Naga had remanded the suit in exercise of the powers under Order 41, Rule 23A, with a direction to the Learned Trial Court to obtain expert opinion as to the signature exhibited by Exhibit 2 in the sale deed, bearing number 1183 dated 22/5/2007, exhibited as Exhibit 2. This court had duly perused the state order, and from a perusal of the state order, it revealed that the plaintiff has filed a suit seeking declaration that the registered deed of sale number, sale deed, registered deed of sale bearing deed number 1183/2007 is a manufactured, forged, and fraudulent one. And it has also been mentioned that the signature, in as much as the plaintiff did not sign the said document. Along with the said declaration, the plaintiff sought for various other declarations in the suit. As regards the right, title, and interest over the suit property to the extent of 1/4. The state suit was the state suit being title suit number 26/2007 was dismissed by the learned trial court by the judgment and order dated 19/12/2012. It is against that the appeal was prepared before the learned first appellate court, which was registered and numbered as title appeal number 4/2013. This court, upon perusal of the impugn order, finds that when during this court have duly heard Mr. R. Barpudari, the learned counsel appearing on behalf of the appellants, and Mr. G. Bharadwaj, the learned counsel appearing on behalf of the respondents. A specific query has been raised to both the counsels as to whether any of the parties to the appeal had filed any application under Order 41, Rule 27 for the purpose of adducing additional evidence, taking into account that neither of the parties had taken any steps during the trial as regards obtaining the expert evidence in terms of Section 73 of the Indian Evidence Act, read with Order 26, Rule 10A of the court. So, the learned counsel appearing on behalf of both the parties submitted there was no such application filed. So, under such circumstances, as the evidence were already available on record, the learned first appellate court ought to have decided the suit on the basis of the said evidence, which was available. Or, if the learned trial court, first appellate court was of the opinion that further evidence was required, the court could have very well exercised the powers under Order 41, Rule 27B of the court, and thereby could have directed exercise such powers in terms of Section 73. Exercise such powers. However, that not being done, the matter was remanded back to the learned trial court, which on the face of it was in violation to the provisions of Order 41, Rule 24 of the code. Accordingly, this court therefore sets aside the impugn order dated 12/8/2006 passed by the learned 16 passed by the learned District Judge Nagaon in title appeal number 4/2013, and direct the learned first appellate court, that is the learned District Judge Nagaon, to decide the said appeal in accordance with law. They decide the appeal, and taking into account that the dispute has been pending since 2012, and almost a decade have already passed, the matter be taken disposed of as early as possible, and preferably within 6 months from the date of the instant order. This court further, taking into account the above, vacates any stay order passed to the title suit number so and so. There was a title suit number 26/2007, and the order.
It was dismissed, so there is no question of stay.
No, there was a remand, na.
Remand.
Once there is a remand, it will automatically open. Therefore, this court further vacates any interim order so passed, and direct the trial first appellate court to decide the said appeal within the time frame as above mentioned. Records have not come. No? So,
And respondent number 4.
this court also takes note of that the LCR have not been received, and as such, the registry is directed to duly communicate the instant order to the learned trial. The parties who are being duly represented in the instant court are directed to appear before the learned first appellate court on 3rd of July 2024 for further proceedings of the appeal.
That 6 months, let it be from 3rd of July.
What?
That 6 months which because
From the date of appearance.
let's see from date of appearance.
Give it.
And so
My lord, the observation, if any application is filed.
Good, sir. This court further observes that the observations so made by the learned first appellate court in the impugned order which have been set aside shall not influence the learned first appellate court in deciding the appeal.
And if I file any application, that may be decided as per.
Huh?
If I file any,
That is your. I would not say anything unless without the baby being born, there is no marriage till now, and you are asking about the child, and the child will go to the engineering college.
because my lord, trial court, my lord, have come to specific findings. They had all the opportunity to adduce their best evidence. They did not.
Wait, I am not getting that very important thing. The illustration is very relevant.
They did not.
Yes,
They
the
had all the
illustration says exactly your case. Illustration says that if A says this document is the will is forged, or this document is forged, B says this document is genuine. A cannot prove on his own that the document is forged, and B on his own cannot prove that the document is genuine. This is the illustration.
That is illustration to section, my lord.
Which section?
That illustration, my
That
lord.
is what I am saying. I am trying to find out. That is what he cannot give evidence to the defense. Exactly your.
Yes, my lord.
Sorry.
21, section 21.
Yes. The question between A and B is whether certain deed is or not false. A affirms that it is genuine, B it is false. A may prove a statement by B that deed is genuine, and B may prove a statement by A that the deed is false. But A cannot prove a statement by himself that the deed is genuine, nor can B prove a statement by himself that the deed is false.
So therefore, my lord, third party.
Expert opinion.
Whatever you do, that is your lookout. I am not saying that. You can. There are other people also, na, who can very well. You see this particular
All the
section
evidence
47.
have been, my lord. They have to, my lord, adduce evidences, my lord.
A person is said to be acquainted with the handwriting of another person when he has seen that person write. So that person has to prove. You have to get another evidence if you wish. Yes.
My lord, I'm sorry, I just overheard the name of Procedural.
Oh. No, I was saying that why you are waiting out here.
The matter is which was acquitted in 2017.
Which one?
So I've just ordered.
Okay, summary. Anyways, we finished the 2016 matter.
I'm sorry, my lord.
No, it's okay. No.
I'm so obliged.